Yes.
Yes.
This matter is very much connected with item number 31, 32, 33, my lord. Maybe taken together at that time when the matter is discussed.
All right.
My lord, one more small there, my lord. I have filed affidavit in item 33, my lord,
Hmm.
yesterday.
Hmm.
That may be called to record.
No. Why have you filed it yesterday?
My lord, some records, just some one record, my lord, which received very much, my lord, lately, my lord, from
We
the
don't know.
department.
Then you should have taken permission to file it. Why did you file it when you know the matter is listed today?
My lord, very much connected, my lord. That's why, my lord.
Maybe.
Only one document.
You
my
were
lord.
making a mention yesterday, day before. You should have mentioned that there is an affidavit. We want to file it, although the matter is listed. Allow us to file it.
My lord,
Why did you not inform the court? Why are you filing in a matter which is listed? We don't get the opportunity to see that affidavit. Only you know.
My lord, only one point, my lord. The documentary. Just,
Whatever it may be, if there is a
copy,
procedure, follow it.
very simple, my lord. Not so
Now
very
you call
long.
it, don't connect it, just call it. Call it.
Alright.
Yes.
May I please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 27, your lordship. Lordship may kindly adjourn the matter for the day.
Lordship, the urgency, Lordship, can kindly be taken up on Monday. If it was fixed on urgent basis only. Otherwise,
What is the matter?
it's giving promotion, Lordship, and granting promotion from Lordship ASI to SI, Lordship. So, Lordship, the petition, the new promotion will come up.
No, if you are agreeing for an adjournment, we are adjourning it. Otherwise, we'll call it up.
No, I am not playing, Lordship. They have got to pay.
No, if you agree to the adjournment, then we are deferring it after July.
Because she has requested, Lordship, her personal problem. So, that's why. And she said that on next week she will.
Next week is motion day, it's not for
Just-
admission hearing.
Yes, Lordship may fix it and it not delete it. It doesn't fix Lordship, then we cannot take.
Ah.
We'll take a chance. Monday, Lordship.
Monday? No, not on
Then
Monday. I can't fix it on Monday.
Then Thursday.
Today is Thursday. Not next week. Next week is only motion day. We're not fixing matters like that.
Tomorrow, Lordship. Can it be?
The today only. Why not tomorrow? Why not today?
Today, Lordship, she
Let us hear you what you have to say. What is your case?
as she requested charging in the file.
Please for the respondent, let us understand what is your case.
I have not got the file.
Say that.
Yes, because
Say
she,
that.
yesterday, Lordship, she has requested.
Then we are adjourning it. Matter stands deferred to be listed after the ensuing vacations on a request made by the learner CGC. Released on 17th July. Mr. A.R. Tovinda.
Here, please, Lordship. I have filed a delegatory application.
Day after tomorrow. Tomorrow. Right, tomorrow.
Yeah, Lordship, I beg to mention for listing, my lord, some matter for next Monday.
When did you file?
Another 15.
15.
Yes.
Should come. There is no defect. Subject to defects being cleared Monday.
So, lordship, with the consent of the other side, I beg to mention item number 14, your lordship, may be adjourned today because the engaged counsel, Mr. P. Chaudhary, due to some medical accidents at his home firm, will not be.
You are for the respondent.
I am
I'm for the response.
for the petitioner, my lord. My lord, have heard this matter, my lord. And it was upon mutual consent that it was fixed to them. My lord, can you come out on 22nd, my lord?
On Monday.
Monday, my lord.
14 Monday. Yes.
I beg to mention for listing, lordship, matter relates to suspension, lordship. It may be listed on 24 lordship,
No, for motion or admission?
admission, lordship.
Admission after vacation. Admission matter will come after vacation. 17th. Correct the date and give it to the court master. Yes.
Lordship, in item number 25, the respondents have filed a affidavit in opposition to lordship, against which we will file a reply. So, your lordship may kindly take up the matter.
25 on the request made on behalf of the petitioner stands referred to be listed after 4 months, enabling them to file their affidavit. They join them.
Thank you.
Motion, admission,
Motion.
motion matter, when was it filed?
Filed on 16 year. You know, on tomorrow.
Tomorrow. What is the urgency?
Urgency, my lord, one matter is suspended from service
already regarding a payment matter.
What is the subject matter of the matter?
Suspension here.
Suspension.
Right.
What is the urgency? They come on
Urgency-
Monday, Tuesday.
urgent- Well, on Friday, you say one matter is comes up Friday matter relating to
comes-
similar matter.
What similar matter we don't understand. It's filed by the same person.
Same petitioner. you know.
Same petitioner
Yeah.
filed 2 cases against the same suspension order.
On the same cause of action, he was suspended.
Ah,
Yes, file a writ petition
challenging
regarding
that.
payment of salary, but they have not, instead of honorable court's direction, they have not paid the salary. But still it is pending, your lordship. That matter will come tomorrow.
But that is not for motion.
That is admission. But now it is same cause of action, your lordship. He suspended from service.
Suspension.
Matter will take
Monday, what is the difficulty? You are not available on Monday.
that matter will come tomorrow.
No, but are you available on Monday? Not available.
Tomorrow, my lord. It is convenient. Your
Convenient to you. Okay. Or
Master. May I please, your lordship?
खाली भी तो फाइल हो चुकी है. Yes.
My lord, similar issues, my lord, matter pertains to my lord pension and higher wages. My lord, similar issues are pending before the division bench of Madras High Court, which is coming on 22nd, my lord. And Calcutta division matter is coming on
How
20th.
is it binding on this court?
But they have requested, the outstation council has requested me to make a paper for lordship. Please the matter immediately after vacation.
What do you say, Mr. Tasman?
The last
Matters pending before other high courts are not a ground for adjournment. Unless it is, you can say that all right, it is pending before Supreme Court.
some other ground, it can be adjourned. Not for this ground.
On this ground, this is a valid
Technically.
ground for seeking an adjournment. That some matters are being heard in some high court. Is there a direction that all these matters should be heard in a particular high court by the Supreme Court?
Ground cannot be adjourned. For other ground, can be adjourned. They have concluded our argument. They have also started their argument.
The outstation
some
lawyer is
extent,
to reply,
To
my
some
lord.
extent, they have argued their case. Now that they
One last chance may be given,
that can be.
immediately on the reopening.
So immediately on the reopening may not be convenient for the court because we have already fixed so many matters. This matter was fixed in the presence of the council.
Yes.
No, but on last occasion also, he was not there. I prayed for adjournment.
Yes. What to do?
The last chance they will given. Not on this ground, the matter is adjourned, the High Court, the other High Court.
Earliest we can give you is 13th August.
August.
There are already matters fixed, therefore. 13th August.
Can it be on the last part of July?
Last part of July, the only date we can give you is
30th July?
30th July, already 40 matters are fixed. Yours will be the 41st matter. Don't know, you can take a chance if you want. 30th July, on the request made by the council for the respondents. Matter stands before. For the reply, for the arguments of the respondents. Released on the 30th of July. 30th July. Item number, up to which item number? 1 to 9.
My lord, I have got some synopsis or bullet points and matter relates to the regularization. There is a resolution a long back. They are working more than 30 years. So then after the decision of regularization, nothing was done. So my lord, the case of the petition is covered by Uma Devi as well as the current recent judgment. So they are entitled for regularization. My lord, kindly see, my lord, I lead my race. And kindly see page 54. How they get initial appointment was made. It's long back in 1989. There is some post in the NIT Silchar. Now, previously just known as Regional Engineering College Silchar. So, from employment exchange, some name was after scrutiny sent to this engineering college, and after scrutiny they sent calling letters to the present petitioners and members of petitioners association. They or some of the calling letters I have annexed as annexer C series. This petitioner number 2, Champalal, for his calling letters I have annexed and other petitioners also annexed. All I can. Here calling for interview.
They responded. Union.
I don't- here.
They are working under NIT.
Yes, my lord. At present NIT, previously Regional Engineering College Silchar. And my lord, their appointment through a procedure, my lord. At that time, paper publication was not there. The employment exchange used to send the name and they conducted selection test. And this is calling letters. After that, my lord, page 60. I have with the extract of this split C and D, my lord. So panel was prepared after being selection, and from this panel they used to regularize or used to appoint them as a regular employee. That is why selection test was taken.
Stand of the respondents in their affidavit.
They say that Uma Devi is there, and other recruitment rules which comes in 2019 that does not allow you to automatically regularize. You see in the selection test. Otherwise, your case. But our case is that prior to Uma Devi, my lord, there is a decision. Not only decision, Honorable High Court's direction, division bench. When I coming to that, my lord, please.
No affidavit has been filed.
But they have filed affidavit taking that stand, my lord.
They have.
Yes, they have filed affidavit. This is complete, my lord. Their stand is, my lord.
There is no affidavit here. There's only one affidavit on behalf of the petitioner to bring the track record. And the writ petition. Yes, affidavit doesn't exist.
My lord, your lordship is saying 4853 or
2510.
25, but I am talking about 4853. my
How do
lord.
we know you're not saying?
My lord, see, for
Why two writ petition?
my lord, when there is a direction notice in honorable court, without considering the case of the petitioner, he has not fill up this post, but they have filled up their post.
There is a written instructions available in the file
My lord,
saying that these posts are not filled up in view of the interim orders.
my lord. then my lord, that should be recorded, my lord. If their instruction is there, will be protected. But I let my case, my lord, 4853, subsequent case, my
Yeah.
lord.
What is
Why?
the stand of the respondent?
My lord, we have challenged this, my lord, uh, 59,
You're working as what?
my lord, grade CND, that is, my lord, grade 4 and grade 3.
Where are your appointment orders?
My lord, I have Annex 1 appointment letter, page 74.
What is that, 53?
My lord,
Page number 53,
yes. 54 is the calling letter.
52.
My lord, yeah, your lordship going through the 2510 or 4853?
You said 4853?
Yes, yes, my lord.
Yes, page number 52.
It is the NIT, they are the NIT, they have, it is the registration and this petitioner's office bearer, that is the things. Main things at page 54, my lord.
54
Yes, my lord, there's a calling letter, my lord.
calling letter.
Yes, my lord. It's, here it is, my lord, clear that their name was sponsored by my lord, employment exchange for selection. And
Thereafter, what
selection.
happened? Thereafter,
Thereafter, my lord, their select panel is prepared, Annexer D, page 60. Yes. 1 week, they have taken the test, selection test,
post of
24,000.
laboratory assistant.
My lord.
For which post?
But grade 4 and grade 5.
Page number 60 says it's a post of laboratory attendant.
My lord, that is grade 3, my lord. And another is, and 62, my lord. These are grade 4, my lord. Who come chokidar like that. Page
Yes.
62.
So the petitioners in this 4853 are appointed as what?
As some are cook, some are lab assistant, some are technician, some are grade
Both,
3.
both grade 3 and 4.
Yes, my lord. CNP. Correct.
Then
Yan, my lord, on appointing letter, page 72, I have annexed.
72.
Yes. Shows that our appointment, temporary appointment was given, it is a resultant vacancy. Then, my lord, they were extended from time to time. And at last, my lord, page 73, Annexer F, 9392, my lord, allowed to continue, my lord. And this extension is now comes to an end, they allowed to continue. But no regulation.
You are an independent organization or under the central government? The NIT?
NIT works, umbrella association of all the workers.
Is it a central government institute, state government, independent?
Under the statute, my lord, NIT.
Statute?
Yes, central government, controlled by central government,
Controlled
Ministry
by
of Human Resources.
All right.
Then, my lord, this is the continuation order. And my lord, I like to lead your lordship page 118, kindly see.
118.
116 is the relevant. That is the recommendation of the committee formed by letter number so and so. This is a very recent 24. Why I am showing that, my lord, page 118, my lord, present status MR workers at NIT. It clearly shows that since 1990, we are working against the vacant post. Now also we are holding against the sanctioned vacant post. That is the committee, hyper committee has given this. Regular vacant post, we are still holding without being regular. That is why I'm showing. Now, my lord, what happened, my lord, in the meantime? Again,
What was the recommendation?
Recommendation, they say that report status may be given, or they suggest that they to form a society will help them like this. They have not talked about our regulation, although there is a direction of this honorable division bench to consider our regulation. So I am coming to that mind. But here only says that we are still holding the regular post. And that we are not regulars against that post even after 30 years. And more than 10 years without assistance, without the support of any judicial order, we are holding them. Among the panel, my lord, annexers age 75. Some similarly situated persons, they have regulars, but after that they stop the regular. This is the regular post they are appointed. Age 70.
By the recommendation, one set has been given the status of temporary workers. And the other set has been given equal pay for equal work status by the recommendation.
My lord, it is recently the report.
Page number 119.
Yes, my lord. Then, my lord, I kindly see, my lord, page 75.
What is this writ petition here?
My lord, what happened, my lord? There is a resolution, page 78, kindly see annexer I. In 2001, my lord. Long back 2002, 2001. Page relevant, page 79, last regulation. Regarding regularization, they said that as and when vacancy available, master workers and when the vacancy exists, master workers will be regularized as case manner basis. So after the meeting, a notice is issued, and this principal has issued the notice, shows that the regulation will be done. Annexure I, page 78, relevant 17. Mother,
This writ petition at 125 was filed by you.
120. No. And another repetition, our singular issue that filed by law. Then, mother, NIT.
Who filed the writ petition at page 125?
Yes.
Yes, what? Who filed it?
We filed it.
You filed it.
Yes.
So there is a direction
Direction.
at page number 134.
Yes, my lord.
Then
But as per direction, my lord, before that, my lord, division or bench order is there also. If your lordship like to leave is 100, my lord.
100.
Yes. Previously, their stand was that in writ petition, that since ban, central government ban, and since there is a ratio problem 1:1.5, so at this stage we cannot regular you. Then appeal is filed, and after appeal, page 100, Honorable Division Bench says that at that time Umadevi comes. That is why they on the light of Umadevi, although not mentioned here, says that you take the process of regularization step by step. Those who are 30 years or like. This is 5/12/2008, my lord. 2012. They have taken initially some steps, my lord. Page 102. 102 and 103. Is a notice.
The judgments are already, there is directions to take steps.
Yes,
Then,
but initially they have taken steps, but not completed, my lord. That is why they want to fill up by open advertisement.
This 103 is a resolution of what?
Pursuant to the honorable division-based direction, they have taken resolution that we will number 3, 4, and 5. Kindly see, my lord. 3, 4, and 5 resolution is adopted 22nd 9, 2013. Even they also recommended that training should be imparted if they are not qualified for technical course. And 16 numbers already decided to regularize from this kind. So, my lord, after that it stops, my lord. Then 10 years, nothing has done. Suddenly, 7/7/2023, lot of posts, my lord, surfaced, vacant post. Now, depriving this petitioner, they surfaced this advertisement for to fill the grade C and grade B.
You fulfill the criteria.
Yes, my lord, our education qualification there, we are serving a vacant post.
You are claiming, you are identifying yourself with which posts?
My lord, grade C and grade B.
What are the name of the posts?
My lord, grade D, my lord, I think it is a sweeper, cook, peon, night chowkidar, and grade B, my lord, this is clerical post. My lord, this technician, senior technician, that is for demonstrator in science, my lord.
In the advertisement
Yes,
of 7/7,
my lord.
which are the posts you think
My lord, 12.
is commensurates your qualification?
Here, my lord, this advertisement, my lord, particularly grade C, senior technician 9, a senior assistant, then technician, junior technician, minus 12, 13, 9, 10. These are the posts they want to fill up. So we file a repetition against this, my lord. Your lordship has mentioned, page 125. And this honorable court in earlier occasion is direction is already division bench has given direction to consider the regulation. So a speaking order may be passed regarding this. And speaking order is against us. That is why new repetition, this instant repetition we file.
Where is the speaking order?
Yes, we have 135. Speaking order, my lord. Speaking order, they also says that NIT can itself take its decision, my lord. But they said that in 2013 also, ministry has taken some steps, but at that time, there is some 9 posts is excess. Strength is 168, then 58 new posts sanctioned, it becomes 25. But 235, there is 9 posts still excess. That is why financial burden will go. That is why at that time, 2013, that was not done. But these 10 years, when a lot of sanction posts surfaced, vacant posts surfaced, but they have not taken these steps. Now they take as another plea that the recruitment rules, there is no automatic regulation. They negate the whole things, my lord, since 2001. And of paras 18 kindly. It's clear cut recommendation that if there is a scope, it should be regularized. 18. Then, my lord, they also come that a mathematical, my lord, there is a 9 post if still modern strength is now 226, yes, 226, but still 9 is excess. That is why at this stage they cannot. It's the situation in 2013. They can do it 2014, 15, 16. Now 2023, they want a fresh recruitment. They are considering us. Although there is a clear-cut direction. Even Umar Devi also says one time, regulation if we working sanction post. Now they have given different suggestion if from a society to negate this our claim. That is why we challenge the speaking order. The division bench direction is not complied with.
There is no specific direction by the division.
For
regularization.
Not regulars to consider the
They have
aspect of
considered.
regularization.
Come to page number 136, serial number 3.
My lord. Thereafter, NIT comply with the direction of the government. That there is no scope for regularizing the service. We are agreed by this. That is why we approach your lawsuit.
136, if you
Yes.
come at page serial number 4,
My lord.
there is a reference of another writ petition,
My lord.
Sirajuddin Loskor.
Yeah.
You have the order.
That order probably stays not.
Yes, Mr. Chaudhary, where are these orders of the High Court?
Take up the matter at 2, I'll place the order.
Huh?
The lordship can take up the matter at 2.
Oh.
The order.
136, serial
Yes.
number 4,
Yes, yes,
there
this
is one
order is
order, and 137, serial 6, there is another order.
Another order, 2 orders. She can take up the matter at 2.
That's our only contention is that the
No, you can have as many contentions as you want,
yeah.
but you are before a court of law asking for exercise over powers under which jurisdiction? 226. You must make out a case
Yes.
that you are entitled under this particular aspect, this judgment of the High Court, that judgment of the Supreme Court.
Correct. Supreme Court judgment.
Where raising a contention that you are working, there are so many judgments available, you are not referring to even a single judgment.
Judgment is all with me. Recent judgment is with me. I come to that aspect later on, my lord. That Jagdu's judgment and judgment, 3 or 4 judgment.
No, later on means after hearing of the case, what is left to be heard?
My lord, my judgment is there, my lord, right now. I can. Jagdu says that my lord, temporary level should not be continued years together. At least 10 years after one hand, the regular work is done. So there should be a regular price. And then, my lord, this is another judgment, my lord.
All right, you come back at 2 p.m., we'll take it up again. Get the judgments. 2 p.m.
Publish.
Found a PPO, my lord, although it is not very visible, my lord, but it was issued, my lord,
in the year 2011, my lord. This is a
Not
scan
very
copy,
visible means hardly visible.
lordship.
Then get a legible copy. Or you read it to us.
Yes, my lord. This is from the Treasury Officer, Nalbari Treasury, my lord. Is it legible? Lordship, this is a, I think, rebel legible.
What is the grievance, Mr. Chaudhary?
That I am getting pension, madam, not on the revised pay, madam.
You want a revised pay.
Yes, madam. Because communicated also by the department.
Lordship, may kindly peruse the last order, my lord.
Last order.
11/5/2026.
Yes.
Petitioner being the legal head that is employee seeks the said benefit on the basis of the service book which has been lost and further relying on the basis of fixation so and so is communicated. His service book was lost, my lord. Thereafter, for reconstruction of the same. So, my lord, the office has found only this PPO in respect of petitioner. It was of 2011.
So, decrease the pension from the revised pay. Now that the PPO is there, you can decide on whether he is entitled to revised pay or not,
Yes.
as per the claim.
Already decided.
Already revised pay has been
That's a-
granted, my lord.
Annexure 6, page 18, madam. One director,
What is the difficulty for not release?
accountant general has been requested, madam.
Yes, Accountant General. Get it by Monday. Take it on. Monday.
And I have handed over the copy of the PPO to the council for the state, as well as I will hand it over to the company.
Is there any affidavit filed?
No, ma'am. No,
Somebody has filed an affidavit.
Lordship, we have filed the affidavit.
So it is Accountant General who has to sanction it.
Start from the.
Yes. Where is Mr. Chakraborty? Please call him. Let us understand what is the problem. Please ask him to get instructions by Monday. Monday. Relist on Monday, enabling the standing council appearing for Accountant General to obtain the required instructions as to why the revised pay, benefits of revised pay has not been given to the petitioner. It has not been released to the petitioner by making of its authorization in family pension. Your
Yes. Yes.
family pension.
Yes.
In respect of the pay revision granted services of her late husband. The authorities have traced out the PPO dated 8 August something,
18th August, my lord, 2011.
18 August 2011.
There is a reference number in the letter, my lord. Communication.
Which communication? 26/5.
26/5 communication. There is a reference number if that could help.
Reference regarding what?
Very clear.
So the I have annexed it, my lord. Annexer one is the document, my lord, regarding person pay order of 2011, so.
18 August 2011.
Yes.
And Mr. Chaudhary has also referred to the order passed by the appropriate authority. Thereby, the administrative department, namely the health department, has already acquaintance go to regular rules. Cooperating with the necessary revision. Revision has been done.
Yes, my
And the request was already sent to the Accountant General's office by communication dated 19/1/2024. However, till date, the revised pension has not been released. Family pension. So, Mr. Chakraborty will advise the court as to the status released on Monday.
lord. This was my lord. The petitioners, they had completed their apprenticeship training as boiler attendant. This training was imparted as per the Apprenticeship Act 1961 by the respondent number 1, that is the Indian Oil Corporation Limited, Gauhati Refinery. The training started from 11/2022 and it was completed on 10/2024.
Yes.
It was a 2 years training, my lord. My lord, kindly come to page number 16. So after
16.
page number 16,
Yes.
we have annexed certificates with page 16, 17 pertaining to the three petitioners. I'll read just one. After completion of the training, the respondent number 1 have issued us this certificate. This is to certify that unto does apprentice training number so and so, registration number so and so, and contract number so and so has completed 2 years apprenticeship training as trade apprentice boiler attendant. This is to be noted, my lord. Boiler attendant under Apprenticeship Act 1961, 1973 at Indian Oil Corporation Limited, Gauhati Refinery from 11/2/2022, 11/2024. However, the final certificate will be issued by DOP RDA as per his or registered.
There was some mistake in the subject.
Yes, my lord. Kindly come to page 19.
Bachelor of Science.
Yes. Bachelor of Science.
Then it got corrected.
Yes, my lord. It is corrected, my lord.
Then what happened? Where is the correction? Corrected one?
178, my lord. One 178. Got to 179. 181. 78, my lord. Page 170.
178.
They have now corrected it, my lord.
This is also Bachelor of Science.
And area of domain boiler attendant. Now they have corrected. Now we are saying that our contention is that you have uploaded, the IOCL have uploaded wrong data while filling up the contract form. And and they have filled up as Bachelor of Science. Whereas they should have filled it up as boiler attendant. Because of that, certificate issued to us was it is mentioned as Bachelor of Science. But the stand of the respondent is that IOCL that it is we who had filled the data in the computer system. If their affidavit, I'll take your lordship to that also. We have replied to that affidavit that no, we have no authority.
Affidavit filed in which manner?
Affidavit filed in it is WPC 7069.
General Manager, IOC.
Kindly come to page 154. I'll take your lordship to your stand. Para 7, page 154. Paragraph 7, there stand that the answering deponent state that when the petitioners had joined their respective apprenticeship training, the portal which was prevalent was the NETS 1.0 portal, and all the details of the petitioners were filled up by the petitioners themselves and uploaded in the NETS 1.0 portal. The data which were uploaded by the petitioners can be accessed by the petitioners alone and cannot be accessed by the Indian Oil Corporation. My lord, they have taken this stand, my lord, on their affidavit. Now kindly come to page number 163 of our reply affidavit, then I'll take your lordship to the relevant provisions. Page 163.
163.
163.
Yes.
Para 6. That with regard to the statement made in para 7, the answering deponent states that the respondent number 1 and 2 have wrongly submitted fact that all the details of the petitioners were filled up by the petitioners themselves and uploaded in the NETS 1.0 portal.
This is their statement versus your statement.
Yes.
So what is correct?
I'll take your note. Ours is correct, and how I will show. So we have replies, we have given specific replies that that statement is not true. May I read this paragraph finally?
No, you tell us what is your guns here. What are you seeking from this court?
My prayer, my lord. And we come to page number 12, my lord. Page 12. I have two prayers. One is already addressed. The second prayer,
Address.
yes, is already rectified now.
Right.
Now, what remains is my first prayer. They should call me for the skill proficiency and practical test for the post of Indian Engineering Assistant or PNE.
Pursuant to what? Some advertisement?
Yes, ma'am.
Where is that?
And we come to page number 27. Page
7.
yes. Section 9.
You are applying for which post?
My lord, at page 27 itself, post code is 202. Senior assistant 4, power and utility. Then there is Gauhati, my lord. Under Gauhati, there are 10 posts. Unreserved is 4. 2 of the petitioners are under unreserved. And OBC NCL is 3 posts, and 1 of the petitioner is claiming that it is the NCL.
So what is your qualification?
My lord, my qualification is BSc. That qualification part, my lord, kindly come to page 31. Required qualification at page 31.
Yes.
Capital B, qualification parameters and work experience criteria. Roman 2, that is the post I am concerned with it. Senior assistant 4, power and utility. The qualification required is.
So what is your qualification?
Mine is this BSc, my lord. I am BSc, my
Your
lord.
BSc.
Yes.
Your BSc.
With
That is
maths, physics, and chemistry.
BSc Maths, Physics or Chemistry, along with boiler competence.
Yes,
That you have got.
I got it. They can call me for the test, my lord. Now, their contents.
What is the, this is in 24. This advertisement is of 2024. Now, what is the status of the selection? What is the status of the selection?
Appointment has not been.
Selection over.
Yes.
When was it there? When was it conducted?
Hereby made clear that the recruitment appointment order, if any, issued with regard to the post of junior engineering assistant shall be subject to the final orders that may be passed in this repetition. Order dated 3/1/2024.
When were the selections held?
Election notes after SPPP is not complete.
After?
SPPP.
What is STPP?
Skill proficiency. Yes, ma'am. That
When,
is the
when
last
was it held?
skill proficiency test. Computer-based test was held on 20/09/2024, and skill and proficiency.
You were not called for the test.
No, I was not called on 3/1/25.
3/1/25. And when were the corrections made?
Corrections, not they have. Corrections were made on 18/11/25. 18/11.
18/11.
Yes. It's 178. Are the second, third, and fourth highest scorers. OBC category, he is the highest scorer. And in the general category, the other two petitioners are second and third highest scorer. Only for this certificate at page 178, they were rejected. So subsequent to this certificate, there has to be a
No, how has the, what was the process undertaken to correct the certificates?
they have applied.
Your case, your, yes, yes.
Because I am representing the BOPT.
Your,
I am representing my respondent number 3. That is BOPT.
Oh.
And it is the Board of Practical Training. So ultimately, NATS is a scheme and BOPT is the organization that implement that scheme. Basically, this particular certificate has been issued by BOPT. Now, when this matter was, when the matter was going on, dispute arrived because in a particular column, subject field, it has only shown that petitioner is eligible as Bachelor of Science. but he has thereafter completed his apprenticeship training on boiler attendant. But that particular boiler attendant has not been reflected in the subject. So initially they sought a clarification, and that particular clarification has been offered to the petitioner. And thereafter, after consultation with the Ministry of Education, a fresh certificate has been issued, the respective petitioner, and that has been placed before the.
Now, the first certificate that you issued,
Yes,
minus the boiler,
yes.
diploma or qualification or whatever, was issued on what basis? On material, on the information available where?
My lord, even in that particular petition, it might not come to the second page, where it is specifically mentioned that he has did his apprenticeship training on broiler attendant. But in the subject field, it was not mentioned.
Subject was not mentioned.
Subject, in this particular subject field, it was not.
Not mentioned where?
Sorry. Just a moment. Yeah. Lord, may kindly initially come to page number 19 of the report. That is the initial certificate that has been issued to the Concord Das. Page 19, annexure 4. Now, here my lord will find.
So this was issued by this agency.
Yes, my lord.
Who you represent.
Yes, my
For
lord. Because this is a
issuance of
standard
this-
format, my lord.
Huh?
This is a standard format.
I know
of any
standard
certificate.
format, but from where did you get these information? From data?
The data I have received, my lord, whenever a particular apprenticeship completed his training under a particular employment, it is basically the responsibility of that particular employer to upload all the details.
Employee,
Employer.
employer.
It is not the responsibility of the employer, my lord, as per the statute is concerned. Because that is specifically mentioned in what I have come to understand, my lord. I am referring to Apprenticeship Act 1961 at page
Apprenticeship Act.
19, my lord. Because I have taken out this particular act in a draft pages.
Page number?
No, section 19, my lord.
Section 19.
Section 19. This particular section relates to records and returns.
Yes.
Records and returns. My lord may directly come. My lord may first read the subsection 1. Every employer shall maintain the record of the progress of their training of the each apprenticeship undergoing apprenticeship training in his establishment in such form as may be prescribed. Now coming to subsection 2. Until a portal site is developed by the central government, every employer shall furnish such information and returns in such form as may be prescribed to such authority at such interval as may be prescribed. So basically, this is the responsibility of the employer to record all the development relating to a particular apprenticeship aspirant.
Now, what is this apprenticeship? Is it defined somewhere?
That exactly
Apprenticeship training. Yes.
apprenticeship.
2AAA.
It has not been specifically.
It is divided. 2AAA.
Practical training of graduate and technician apprenticeship and technician. Now, my lord, whoever wants to complete this boiler attendant training, it is mandatory for him to have Bachelor of Science degree. Unless he have that, he cannot participate in it.
Unless they have.
Unless a particular aspirant does not have the degree of Bachelor of Science, he cannot participate in the training.
No,
For
correct.
Bachelor of
Now,
boiler attendant.
in order to undergo this training,
Yes, my lord.
what is the procedure? They have to apply.
Yes, my lord. There is a particular portal. That portal is perhaps in NAS, where both the employee who want to seek employment and the employer, both of them will have to register in a particular portal. And thereafter, the whole process starts.
What we want to know is, this is an apprenticeship training.
Training.
Now, apprenticeship training will be that essentially it is a training.
Yes.
To make them more capable or eligible for further
Specific
employment,
job.
gainful employment.
Yes.
Right?
Yes.
So for that, they had applied either directly through the portal or some advertisement to the IOC.
Yes.
Is it a case that they have to apply to IOC or they have to apply to in the portal? And the portal will reflect which is the employer under which they are to undertake the training. I mean, what is the process?
First, there has to be an advertisement. Thereafter, a particular person who want to seek
Advertisement for
avail this training,
apprenticeship.
apprenticeship training, want to avail it. First, to my knowledge, they have to register themselves in employment exchange. And thereafter, if they want to participate, then they have to register their names in the particular portal. That is next, my lord. And thereafter, the training shall start.
No, training shall start, will proceed with the selection. Which particular employee is allotted, which employer, who decides that? The employer or the central authority?
Central authority normally does not decide. It is basically the employer.
It's the agency, it is the internal corporation who will issue an advertisement calling for apprentice.
Apprentices.
Then they will apply, selection will take place, they will be enrolled. And after they pass out, we simply issue a certificate that yes, they have done the apprenticeship in our organization. And the final certificate is to be issued by the authority. Now here in this case, my lord, not only is the certificate, your lordship goes to the eligibility criteria, two points were required. One was either he has to have a boiler competency certificate or an apprenticeship training which is duly certified by the boiler authorities as equivalent to a second class boiler. May I just take your lordship that particular provision in the advertisement?
Yes.
Page 31.
31.
This is the crux, my lord. Lordship sees refinery units where boiler authority of the state has prescribed boiler competency certificate with second class. 3 years diploma in so and so, we skip this, my lord. Then we come boiler competency certificate. It is along with boiler competency certificate, which admittedly the petitioners do not possess, with second class, or the National Apprenticeship Certificate in Boiler Attendant under the Apprenticeship Act 1961, with due endorsement of equivalence to the second class boiler attendant certificate of competence by the competent boiler authority of the state of the refinery unit for which the candidate has applied. Now, this is under a particular set of rules, my lord. It is the boiler rules, boiler attendant rules of 2011.
Boiler attendant.
It is a, I did not get it there in the book, my lord. Lordship will kindly have a copy. Okay. 24, my lord. 24 sub-rule 2. A person holding a national apprenticeship certificate in the field of boiler attendant under the Apprenticeship Act 1961 shall, on application, have the certificate endorsed equivalent to the second class boiler attendant certificate of competency under these rules in the state or union territory in which he applies for services. Such endorsement shall be made by the chairman of the board. Now, if your lordship sees the new certificates which they have produced at page 171, page 178, yes.
Yes.
Lordship will kindly have page 179.
179.
This is the endorsement. under 24(2) of the Boiler Attendance Rules 2011, the certificate is equivalent to second class certificate of competency in water tube so and so fire. So, my lord, the certificate which the petitioners are relying on, which your lordship finds at page 20, from 19 onwards, my lord. Even if this is corrected from Bachelor of Science to Boiler Attendant, my lord, then also he is not eligible.
Because of the
Because this endorsement is mandatorily required, my lord.
Now, this endorsement is granted on what basis or what parameters?
These are the parameters, my lord. Once he has it, my lord, it is for the Boiler Authority to decide.
But in the certificate at 19,
Yes.
this was issued by the apprenticeship training scheme
Yes.
under Government of India.
Government.
So, where was why was it not endorsed accordingly?
But that is for the petitioners to say, my lord. Because they have to apply before the Boiler Authority, because lordship has read to a 24(2). He has to file an application before the authority that please endorse this. Lordship will also mark the date, my lord, on 19, page 19. The date is 9/8/2024. The last date of acquiring the qualifications is 31/7 as per the advertisement.
Where is the last date?
Last date, page 39. 39. At the bottom. Cutoff date for reckoning eligibility criteria. The cutoff date for the purpose of meeting age criteria and for possession of prescribed qualification and work experience as applicable shall be 31/7. So on 31/7,
So, you want to submit, you want to say that even if this page 19 certificate is correct
correct.
or assumed to be correct, then also it was issued on 9/8.
9/8. And secondly, my lord, even if 9/8 is assumed to be correct, then this 24(2) requirement is not there. And then, my lord, the petitioners will have to explain as to on which date they applied for this 24(2) certification.
First, why was there no endorsement? One. And secondly, on the cutoff date, why our case should be considered even if our certificates were issued 9 days after the cutoff. Cutoff was 31/7, certificate is of 9 days. Now, my lord, when we got the certificate, that is at page 19, the final certificate at page 19, we wanted to endorse it from the boiler authority. That's point number 3. But that could not be done because the trade was not mentioned as boiler trade in our certificate. It was mentioned as Bachelor of Science. Kindly come to page 134 for a moment, my lord. 134. Page 134. This is issued by the respondent number 3, the petitioner number 1, page 130. May I read? This is to inform you that as per section 24(2) of Boiler Attendant Rules 2011, a person holding a certificate in the field of boiler attendant under Apprenticeship Act 1961 can be endorsed as equivalent to second class boiler attendant certificate of competency. However, in your case, the certificate of proficiency issued to you under Apprentice Act 1961 is in the subject field of Bachelor of Science. Since the subject field on the certificate does not mention boiler attendant explicitly, the undersigned cannot endorse the certificate as equivalent to second class boiler attendant after adhering to section 24 of the Boiler Attendant Rules 2011. So they refused. The respondent number 3 have refused to endorse it on the ground that the certificate at page 19, it mentions as Bachelor of Science.
When did you apply for certification?
My lord, my lord, my application will be before 2011-24. My lord, this is letter is of 2011-24. Not much later, my lord.
This letter is of
20
25
2011-24, my lord, at page 1.
2011.
Yes, my lord. 9/8, my lord. I was given that certificate 9/8, and now that is 2011. Statements. One, Lordship, I will show that, my lord. My lord, may kindly come to page 132 for a moment. Page 132. Lordship, this was written to the respondent number 3 by the respondent number 1. Subject, request for endorsement of National Apprenticeship Certificate in boiler trade as equivalent to BCC second class. Sir, I am writing to bring to your attention a technical error that has occurred during the registration process of apprentices in the National Apprenticeship Portal at Gauhati Refinery. Due to this error, apprentices in the boiler trade have been issued certificates in BSc instead of boiler trade by the National Apprenticeship Portal. This discrepancy has resulted in the State Boiler Authority being unable to endorse the certificates as equivalent to BCC second class. One of the ex-apprentice, Sri Devanga Datta, he is also a petitioner, son of so have been issued certificate in BSc instead of boiler trade by the National Apprenticeship Portal. The National Apprenticeship Certificate and Provisional Certificates issued by IOCL Gauhati Refinery is endorsed herewith for kind reference. I kindly request your intervention in this matter. We urge you to consider the circumstances and assist him to receive the necessary endorsement for his certificate, enabling him to proceed with his career aspirations. So, my lord, this letter was written by the R1 to the R3. And my lord, their contention is that it is our mistake that we have filled up this information. Kindly come to page 174, annexure 33. Who has to fill up? Page 174. For that, if I can take your lordship to section 4 of the Apprentice Act. Lordship had posed a question on the process. I'll take your lordship to the process. What is the process? Kindly come to section 4. Section 4 is contract of apprenticeship. No person shall be engaged as an apprentice to undergo apprenticeship training in a designated trade unless such person, or if he is a minor, his guardian, has entered into a contract of apprenticeship with the employer. The apprenticeship training shall be deemed to have commenced on the date on which the contract of apprenticeship have been entered into under subsection 1. Every contract of apprenticeship may contain such terms and conditions as may be agreed by the parties to the contract.
Right, now tell us one thing, that is advertisement under challenge?
They are claiming under this
Advertisement has given a last date of 3/7.
Yes. 31/7.
31/7.
31/7. My lord, now why? Now they are saying that we did not have the requisite qualification till 31/7. It is, they have committed two mistakes, my lord.
So
Oh.
even assuming that this page 19 certificate, let us assume page 19 read with the later certificate, stated to be 1, and you are considered proficient, apprenticeship. But it will have to be read with effect from 9/8/24, not from 31/7. or prior to 31/7.
Why it is 9/8, my lord? Again, my lord, they have violated the act. Due to their violation of Rule 4, subclause 4, this delay has occurred, my lord.
What is that rule 4, subclause 4?
It says every contract of apprenticeship entered into under subsection 1 shall be sent by the employer within 30 days to the apprenticeship
No,
advisor.
you're not getting the question, but I'm trying to ask you.
Yes, yes,
Let us for a moment accept that this page 19 is the correct certificate.
correct certificate.
Then also it is issued on 9/8
9/8 after 31/7.
after 31/7.
Yes. So, my lord,
Does it give you, is there anything in the advertisement which says that there is a disclaimer that a particular period get the certificate will be entitled to apply?
on this, I get the question. Suppose the certificate at page 19 is a correct one, and the question posed by this court, if I have understood correctly, is that it is of 9/8, but this should have been on or prior to 31/7. Since it is after 31/7, it should only on 9/8, so it is not as per the terms of the advertisement. Lordship, have I understood correctly?
Yes.
So, my lord, on this, my lord, I want to answer, my lord, that I want to argue on two points, my lord, on this. Firstly, my lord, what is the ground of rejection? This was not the ground of rejection, my lord. This ground they have taken much later in this writ petition in subsequent affidavits. Since the ground of rejection was not there, my submission will be they cannot take this ground now. That ground now. This is first. I show the document also. That is first, my lord, my argument. My second argument is, my lord, there is a delay of 8 days, but that delay is due to their inaction. The act.
The question is, why should we extend the date?
Because, my lord, it is due to
the extension of the date, assuming it will benefit you, the extension of the date can also benefit so many other persons.
who are there. One has
Here below the court, on 31/7, like there may be 100 others who are not qualified or who does not have the certificate. Then you approach the court, we extend it for you.
it will not open a floodgate, my lord.
Whether it opens or not is a different issue, but in effect it will cause a hardship to people who otherwise would have qualified on 31/7. But for the fact that they were not aware that there are writ petitions pending in the court process.
My batch, my lord. During my batch, 2 years batch, my lord. During my batch, these trainings were awarded in different districts, my lord, different places, my lord.
Yes, Mr. Deka, what do you say? Is there a scope for them to considering the
Difficult,
why?
because what my instructions are that 2 of them have already got in Bongaigaon refinery, the subsequent. Because we always
How they've got it subsequent advertisement?
subsequent advertisement in Bongaigaon, they have got. That is my instructions, but nothing in writing. Because they
Yes,
also,
what do you say? Two
I
of the
think
petitioners?
except for Ankur Das, the others have got. I think.
Devanga Datta have not got it. He's overage, so he could
Ah.
not apply.
1 and 3 has got.
1 and 3 are in the process, my lord. Their final appointment they have not received. If they are
Their
qualified,
instructions is telling me. That
Yes.
is my instruction. That the final appointment has not been issued. They have participated in the SPPT and everything. They are.
then my lord, this is also open for this advertisement. This is another advertisement. This is another advertisement. Here also they have qualified. They are securing first, second, and third position. Here also, my lord, as per the marks.
They did not participate in the selection process.
No.
They were not
They
allowed.
have passed the CPT. SPPT is left out.
What is CBT?
The computer based test. That is where the marks are allotted to the SPPT skill and proficiency test.
So why they were allowed to participate in CBT?
That is the process, madam. The documents are verified later on. After the CBT, everyone is allowed to sit in the CBT. Then the documents are verified.
Now, is there any dispute that the petitioners did not attend the training?
No. No.
They have attended under you.
They have attended under me, But the thing is that that certificate endorsement is not there, my lord, not even on 9A.
Right, the endorsement not there, but they are otherwise qualified.
No, because that endorsement is required, my lord.
Endorsement has subsequently been given.
Exactly, my lord.
Right.
Subsequently given now, so that is why here they have been considered
But
in the subsequent
you
recruitment.
allowed them to sit for CBT for what purpose?
And
If
that
they are
is
not
that is
qualified.
that is our, because when large number of candidates are there, my lord, we do not verify the documents at the initial stage. Because the advertisement is, my lordship has rightly pointed, advertisement is not under challenge. Had they come on 31/7 or 9/8 itself, saying that no, this is your mistake, for your delay, it has been done, my lord, then it's a different matter, my lord. You have participated knowing fully well what is the cutoff date.
It's not a case that they did not complete the proficiency of the training prior to 30.7. They completed. There is no dispute on that.
But the
The
result,
certification,
yes,
there was some defect in the certificate, which
I followed you.
according to you cannot entirely be attributed to them.
No, but a delay, nothing is attributable to them, my lord.
That's right.
Now tomorrow, my lord, let me give an example. I sit for my HSLs from a particular school. The school cannot give me the final certificate. It is for the CBSC to do so. Now, in the meantime, admissions are called for in class 11. Results are not declared. Results are declared on a subsequent date. I am declared to have passed, my lord. Will the result date back to the exams, my lord? Respectfully, no, my lord.
You don't know. It's on a
That
case-to-case basis.
I rely upon a judgment, my lord, which says the results don't relate back to the exams.
Results don't relate, but subject
Because-
to verification of documents.
No, my lord. Here, there is no dispute that I have passed, I have appeared from, say, Don Bosco school. The school does not dispute. But when he seeks admission, because this apprenticeship training which he does in IOCL, my lord, makes him
Here
eligible
is
for.
a case where you have to understand that in an X, he had passed out from that school.
Yes.
School has no dispute that the records are disputed or anything. They're in order. He has passed out. Certification authority did not issue the certificate. Now he wants to take admission into higher classes. Whether it is possible for the school to accommodate
It will not
him.
be possible. No. Suppose it's a case of passing from class 6 to 7, my lord, whether it is the school which is
No,
involved.
it's not that. It's the question of whether you stick to the rules.
We have
For
to
what
stick-
purpose?
We have to stick to the
For
rules.
what purpose?
To bring in equality, my lord. Because if we now
Equality-
allow them, my lord, it will violate
equality-
16, my lord.
Equality, what respect? Who are the persons who are going to be affected?
We do not know, my lord. We do not
Who
know.
are the persons?
We do not know. There may have been someone who has applied, received his certificate on 10th or 11th. He has not applied. We do not know.
But the problem is that you
Because-
allow them, everyone to appear for the CPT for what
Because
purpose?
that is the advertisement, my lord. It's a large scale advertisement. If we go and verifying, because after the CPT, my lord, a lot number of candidates will be eliminated.
One compartment of cases that, yes, on 31/7, he had completed, or he had completed on 1/8 or any date, then he is not eligible, irrespective of whether the certification is there or not. It is completed. Certification is not issued by the IOCL. Certificate, the IOCL has on record to say that there is some mistake, it needs to be corrected, etc. It would not
That
be
is for helping them in the future, my lord.
right. And they having cleared the CBT only because the certification authority did not issue them a correct certificate on whoever
On
responsible.
the date of clearing the CBT, my lord, they are not eligible because they do not have that certification endorsement, my lord.
So
If
was
you're-
the-
if
so
they-
was the advertisement again.
If they say that no, if the authority said that no, the certification is mechanical.
Where is the certificate? Where is the advertisement?
27.
27, it starts at
What is the
27.
procedure prescribed?
Yes, yes. Page 39, selection methodology.
Selection.
Page 40, clause 7.
Prima facie, all eligible candidates.
Yes,
Would be an eligible candidate.
because the form which fills up, my lord, there he has to say yes or no. Scrutiny of documents, my lord.
What
Third time.
does the form, what are the particulars to be filled up in the online application form?
That form is not on record. It was there in the other case.
Which other case?
No, my lord, it is not before your lordship. Another case it was there, where the candidate had not uploaded that 24/2 endorsement. He said he had it, but he did not upload it in that particular case. Form was available in that
So,
case.
on the date when he applied, the authorities in the IOCL considered him to be
Yes,
prima
because
facie
on the
eligible.
basis of the form, my lord.
Right.
Because there he does not upload the mark sheets. He simply says yes or no. My lord, that matter is listed today, my lord, item number 50, I think.
This court.
Yes. 1092 of 2026.
Item 50.
Either it is 29 or 51.
Huh?
Two matters are there. 29, item 29. It is arising out of the same recruitment, same post, my lord. These cases they have filed that to make appointment. They are connected. Forty-two is the formula. But you will kindly have page 42. There is a heading mobile number. Do you possess boiler competency certificate? The candidate writes yes or no. Then second question, are you a candidate with boiler apprenticeship of so and so having national apprentice certificate in so and so?
You find out what is the information given for this candidate.
Right, find out.
Right? If you have given a statement that you possess due endorsement, then it's a false statement, incorrect statement. Because on the day you have given the certificate, it was not there with you. You verify intel
I'll verify
next week.
next week.
Heard Mr. Khan, Mr. Teka assisted by Mr. N. Google for IOC, Mr. Teka for respondent 3. Dispute in this petition before this court means consideration appointment so junior assistant hyphen Roman 4 bracket person N during post code number 202. Terms of the advertisement issued by the IUCN. Cut-off date for reckoning the eligibility criteria specified in the advertisement is 31/07/24. Additional to this court claim to have undergone successfully the apprenticeship, what do you call apprenticeship training under the National Apprenticeship Training Scheme. After completion, the certificate of the petitioner Don't put us petitioner number
1.
bracket issued on 9/8/24. So,
All of them 9/8.
respect of the writ petitioners were issued on 9/8/24. So, in terms of the procedure prescribed in the advertisement, under the heading selection methodology, the petitioners appeared for the computer-based test. And upon securing suitable marks, they were eligible to skill and proficiency test. However, they were not permitted to admit the fact that the certificate proficiency issued by the National Apprenticeship Training Scheme does not indicate that they had undergone training in respect of boiler trade and as required under the provisions of the Boiler Attendance Rules 2011, Rule 24. Certificate was not endorsed by the National Apprenticeship,
No, madam, the boiler authority.
by the Boiler Authority, certifying that training undergone is equivalent to second-class boiler attendant certificate of competency. So, this according to the was provision of data by the CA were furnished to the National Apprenticeship Scheme. When this was pointed out, there were communications changed between IOC and the National. What is that communication referred?
Page 1,
Some letter was issued
Yes.
indicating there is a error.
page 132.
My lord.
132.
The Chief Inspector of Boilers.
Chief Inspector of Boiler clearly mentioned that there was a technical error that occurred in the registration process of the apprentices in the National Apprenticeship at the Gauhati. So, pursuant thereto, petitioners were, the certificates were corrected and the proper certificate was issued on when
My
was
lord,
it
it was issued on
18 November
18
2025.
Yes, 18 November 20.
issued on 18th of November
2025.
2025. And where it was clearly mentioned in quotes, Bachelor of Science in bracket BSc and area of domain boiler attendant, page number 178 beside it. Whereas since the corrected certificate was issued well after that, the petitioners were not permitted appear in the skill and proficiency test. Being agreed, the present petition is filed. Stock meetings have been exchanged during the course of the hearing. Side, in order to while seeing the process underlying the selection, the advertisement dated so and so. It's seen from the advertisement at under heading selection process, selection methodology, and clause 7 thereof, that admit cards for computer-based test are to be issued to all prima facie eligible candidates. So, learned standing counsel for IOC,
Not standing company. Not
the learned counsel appearing for the IOC submits that decide whether the candidates are all prima facie eligible for issuance of the admit cards for computer-based test, the data or the information uploaded by the concerned candidates while filling up the online form are relied upon. So it is submitted that to the queries, to the various information to be uploaded in the form. If from there it is indicated that the petitioner or the candidate is otherwise qualified, then the admit cards are issued and the same are subject to verification after achieving the desired marks in the CBT and before being permitted to appear in the SBT. So that the court considers it appropriate to call for the relevant records of the petitioner available with the IOC so far as the application forms which were filled up by the petitioner at the time of offering their candidature in response to the evidence. So, then this information will be placed before the court on Tuesday.
Next Tuesday,
Tuesday. That will be 24th.
23rd, I think.
23rd.
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 Obliged.
Please take on.
Obliged, sir.
And there is that inquiry.
My
Yes.
lord, the records they have perused, that day I have submitted, my lord.
Let him come.
Yes.
Afterward.
Obliged. Please, Your Lordship. There was an advertisement under the hand of respondent number 5. Lordship. The advertisement sought for application getting some post of Anganwadi worker and helper.
Yes.
Advertisement was published on 28/11/23. That will also be kindly find at page 21. Last date of submission of application form was given on 12/12/23. I applied on 8/12. The interview was held on 24/6/2024 and the comparative statement was prepared on the same day. After the comparative statement was prepared, the other candidates from the selection list was appointed, but I was not appointed. Then I approached the authority, they denied me to provide any information. I filed application under RTI Act. Then Lordship may kindly find they supplied me is
So according to the respondent, you were a regular student
yes,
on the date of the interview.
that is a condition that regular student not be appointed. The advertisement, that condition is there. But my lord, the advertisement was published in the year 2023. Requirement is higher secondary pass, HSSLC examination. I passed HSSLC examination in the year 2021. Years before I passed HSSLC examination. Thereafter, I obtained admission in degree courses. When the election process was over, by then my degree course was also completed. Lordship may kindly see, I have annexed the examination schedule in my affidavit in reply, Lordship. Page 59. Page 59 was started on 21/5/24 and the last examination was on 29/5/20. And the result was declared on
The final list was published on 15/7/20. Page 31. Page 31. And this was the final.
Where is the certificate of the authority?
Pardon.
Some certificate was issued by the college authority.
Yes, it is there in the affidavit, my lord. Our affidavit filed with the respondent number 2. The last page of the affidavit, my lord, that is the certificate. That's basically communication to the district social service officer, my lord, by the principal. It's crystal, my lord, the petitioner was a regular student. Was in the batch of 2021 and till 2024 was there. She appeared for the semester. In between, my lord, everything happened, and that is why, my lord, if we go by the our notification that is annexed in page 38, annexure B, my lord, the condition laid down rejection of candidates on the following grounds. So, my lord, ground number 4 is regular student of the school or college. So, my lord, prima facie, after the, my lord, complaint we received, it is not that, my lord, we have just acted upon the complaint. No, we verified it. We verified through a proper channel, my lord. We wrote to the Kualpara College principal, my lord, and that is what he responded, my lord, the principal. So, my lord, on this ground, my lord, we could not have given the, my lord, appointment to. So that is why we have sent back to the director has sent back to the, my lord, ICDS project to go ahead with the, my lord, selection. On this ground only, my lord, we could not have, my lord.
The advertisement.
Page 21. Right.
The advertisement is there any ground for rejection? Mention.
Mention. What is page 23?
Page 23, my lord, serial number 9.
Mandate of the mechanism.
My humble submission is that the requirement is higher secondary pass. That I have passed 2 years back, Lord. Thereafter, the advertisement came and I applied.
Have you challenged the condition?
Conditions I have not challenged. But
Unless this advertisement condition remains, my lord,
is very specific, right or wrong, ugly, bad is a very. It says regular student will not be considered. You are a regular student.
my humble submission for the kind consideration of this.
No, you are trying to interpret that regular student has to be attributed so far as high secondary is concerned. That is what you are trying to say.
And
Right.
number 2, that is one, and number 2 is before the final selection list was published, I completed my graduation also. It does not
The date of
affect
interview.
date of interview was of 24/4/24/6/24. And
Where you were student then.
yes, Kaushik. And the result was passed in the month of July 24. It is not a fact that I was appointed during that period and my service hampered in rendering my study hampered in rendering service. That is not also a case for.
When was the appointment order issued?
appointment order, the final selection list, Lordship may kindly see page 31. On the basis of this final selection list, others
How
are
many posts are there?
Lordship,
You are applying for which particular?
Rakhal Puchim, Rakhal Killa, Anganwadi Center, that is serial number 5, page 31. 5, page 31. Page 31. My name is also there. Lordship may kindly see an endorsement down below, approved except serial number 5 only. Approved except serial number 5 only. Otherwise, I got first position in the interview regarding that center.
So who is appointed in this Rakhal Killa?
Nobody appointed as per this honorable court's order. There is an interim order not to fill up the post.
My lord, so long that condition remains, my lord, she cannot be, my lord, appointed. This condition, this advertisement is not under challenge. She has only challenged her appointment.
Now,
Selection.
how do you propose to fill up the post? By fresh admitting.
My lord,
Post is not filled up.
my lord, it will go by, the selection committee will take a call, my lord, if she was in a first position, we'll give it to the second position, my lord, who is there in the second position. If she fulfills all the conditions, my lord.
But second position is somebody there.
Yes, in the comparative statement that is here, Lordship, page 27, Lordship.
Okay.
Serial number 1 is the second position. And my name appears serial number 6, first position.
So you are letting go of a very good candidate.
So, my lord, the thing is that,
In support of my submission, I rely on a judgment, Lordship.
my lord, the thing is that we cannot, there is a condition in the advertisement itself, my lord, and there is a notification to this effect. It is not only that, it is only in the advertisement, my lord. We have a specific notification for this.
Lordship may kindly see paragraph 6.
My lord, then we have to go.
Paragraph?
Paragraph 6, Lordship. Very good.
1 minute. Paragraph 6.
Lordship. Very good.
Yes.
The decision to prefer an uneducated person over an educated person's amount to allowing premium on ignorance, incompetence, and consequently inefficiency. The only fault of the appellant is to have pursued his studies beyond 10th class. If he had discontinued his career as a student even earlier, say after passing 7th or 8th class, he would have been running the shop today. This clearly amounts to gross arbitrariness and therefore illegal discrimination. Pursuing this line, the state will have to be going in search of a more inefficient person, and we do not know where this process would end. If we assume that since a better qualified person has got a better chance for succeed in life, an intelligent applicant who can run the shop efficiently should be rejected, and a dim-witted fellow should be selected. This is an absurd situation.
My lord, this is regarding educated and uneducated. Whereas, my lord, this is not a case here. Here, my lord, all the candidates, they had the basic 12 standard, my lord, pass certificate, everybody had, my lord. Now, my lord, we have to choose between, my lord, whether the petitioner fulfills the criteria. My lord, she did not. And here we have a candidate, next candidate, the petitioner scored 326. And we have a second candidate is 319. It is not that, my lord, we don't have a choice. We have a choice, my lord. But, my lord, suppose, my lord, if we allow this, then, my lord, the floodgate will open, my lord. And without challenging this condition, advertisement condition, then the 2019 notification, my lord. Our guideline says that, my lord. Now he has to challenge the guideline also. We have annexed our guideline, my lord. He or she cannot be a regular student.
Regarding Anganwadi worker appointment, there is a judgment. I could not take out the judgment. The citation is here. Shaini Srize versus Shalini Srinivasan. SC. There is a judgment and observation here is
You
Anganwadi.
get the judgment and submit.
I'm sorry, Lordship. I tried to find it out, but
What is this, a judgment of which court?
Supreme Court, SC.
Give it to the court master, he take it out.
Yes, Lordship. I will.
Give it to him. I hope it is not a judgment you got from ChatGPT.
Very dangerous. I understand, my lord, what has fallen from a my lord, but my lord, my annexure B, page 38. This notification also will come in between, my lord. This has to be also, my lord, satisfied.
Annexure B.
Annexure B of my affidavit, my lord, page 38. Yes, my lord. The advertisement guideline, that condition, my lord, has fallen from this, has come from this notification, my lord. It is the notification, my lord. Now, page 39, down below, rejection of candidate on the following grounds if allowed.
Let him get the judgment, let us see.
My lord.
In the second half. Raghav gives to boiler.
Lordship, the matter will pass over for the time. Yes.
Readings are complete.
Yes, Lordship.
Things are complete, but the lordship, this appellate order is not a part of the court record. There is something that in the appellate order, there is something that is not mentioned in the affidavit.
Appeal has been
Yes, the appellate that was
dismissed.
yeah, they upholded the order of the SP. Dismissed
You
from
have to
service.
challenge the appellate order.
I'm on a limited point, Your Lordship.
Where is the appellate order? Not enclosed.
The
in your-
appellate order is not.
You have not enclosed in your affidavit.
No, in the affidavit is not a transfer.
What is the?
Your Lordship, I kindly peruse page 44. An inquiry was conducted, Your Lordship, there my absence. Thereafter, I was terminated from service. Your Lordship, I kindly peruse page 44. I was in
44.
jail when
44.
44. This is by my wife. May I read, Your Lordship? In response to your letter, in response to your letter issued on 29/8/2023, I, on behalf of my husband, UBC 89 Transit Nazari, the present petitioner, would like to inform you that Your Honor directed my husband to submit written reply to your office within a period of 3 working days on receipt of your letter.
But your honor knows very well that my husband has been languishing in jail since 10/8/2023, and as per your honor's verbal instruction, my husband is surrendered to the Kokrajhar PS on 10/8/2023. According to the till date, he is in Kokrajhar jail. That's around 30/8/2023. I received the above letter from your office, and as per your letter's instruction, I am totally helpless to submit any written reply without my husband UBC 89 Transit Nazari. So I kindly fix another long day for submission of my written reply to your honor after release of my husband on bail. Otherwise, my husband will suffer irreparable loss. In view of the above, please wait to accept my letter and further will please to for submission of written reply of my husband UBC Transit Nazari to release on bail and thus authorized. So the appointing authority, your lordship, thereafter passed the order of dismissing me from service. So you are saying that it was an
Yeah,
ex parte order?
Yes, sir. No, they did not provide me the adequate opportunity, Your Lordship. They ought to have provided me an opportunity, Your Lordship. They have not provided me an opportunity to deal with the inquiry report before the order was passed.
Where is the inquiry report?
The inquiry report, Your Lordship, at page 37 is started. Your Lordship, to page 41. Observation. From the statement of prosecution witness is learned that the delinquent UBC Pradeep Nazariya Kokrajhar DF is found unauthorized absent from police reserve Kokrajhar without any leave or permission from the competent authority. During the course of inquiry, delinquent UBC Pradeep Nazariya Kokrajhar DF has sent 2 WT messages to reserve officer Kokrajhar, right so and so, dated 4/7/2023, so dated 8/8/2023 for asking him to appear before inquiry officer for showing the statement in connection with DP number 4/2023 drawn up against him. This statement was recorded when he was in police remand. So the inquiry officer admits the fact that I was in police remand. As per detailed report of the case submitted by OC Kokrajhar PS on 16/8/2023, delinquent UBC Pradeep Nazari Kokrajhar D was found involved in connection with Kokrajhar PS case number 501/22 under section 363 IPC, added section 371 IPC, based on available evidence in DP file, it is proved that delinquent UBC Pradeep Nazari was found to be unauthorized absent from police reserve with effect from 22/12/2023 without any leave or permission from found to be involved in the case registered at further PS. This thus indisciplined act was misconduct as a member of discipline force is proved. But this was the report there also. I'm relying on a judgment. You can also kindly allow me to rely on a judgment. 1991 1 6580. Paragraph number 13 and 15.
In the inquiry report, your statement was recorded.
Yes, Your Lordship.
How?
I was in jail. I was in jail, Your Lordship.
Where is that finding?
The finding is not there. The observation it is.
Where is that?
At page 41, down below, Your Lordship.
Page 41. Statement was recorded when he was in prison.
Then they have issued a second so called notice to me while I was in jail, Your Lordship. Your Lordship, may kindly peruse the page 46, Your Lordship, the order.
Six.
The order.
Where is that?
I being the page 47 is the I being the disciplinary authority agree with the finding of the inquiry officer and therefore pass the order that he is dismissed from service with immediate effect.
No, you said that prior to issuance of the order of dismissal, another show cause notice was
The
issued.
so cause notice was issued, Your Lordship.
When you were also in remand.
Page 43, Your Lordship.
43.
Page 43.
Does it indicate that you are in remand?
No, Your Lordship. It is my wife who has given a reply at page 44.
When were you released from jail?
On 1/11/2023. 1/11/23.
1/11/2023.
Page 18. I'm not annexed the order, Your Lordship. Okay, paragraph 14. That the petitioner stated on 1/11/2023, the petitioner was granted bail in connection with.
Where is that order of the appeal? Appellate authority order?
That has not been filed yet, Lordship, but it is with me. Lordship.
Give us a copy, let us see.
Yep.
You are not challenging the appellate authority order.
Your Lordship, I'm only praying that I should have been given an adequate opportunity. Your Lordship, may kindly peruse for a moment, if Your Lordship may kindly do it. Paragraph number 13 of the judgment, Your Lordship, 1991, 1 SSC 588. Several pronouncement of this court dealing with Article 311(2) of the Constitution have laid down the test of mutual justice in the matter of moving the class. This court on one occasion has stated the two phases of the inquiry contemplated under Article 311 prior to the 42nd Amendment were judicial. That perhaps was a little stretching the position. Even if it does not become a judicial proceeding, there can be no dispute that it is a quasi-judicial one. There is a charge and a denial followed by inquiry at which evidence is laid and assessment of the material before conclusion is. These facets do not make the matter quasi-judicial and affect the principle of natural justice. As this court rightly pointed out, Gujarat case, the disciplinary authority is very often influenced by the conclusions of the inquiry officer and even by the recommendations related to the nature of punishment to be inflicted. With the 42nd Amendment, the delinquent officer is not associated with disciplinary inquiry beyond the recording of evidence and the submissions made on the basis of the materials to assist the inquiry officer to come to this conclusion. In case his conclusions are kept away from the delinquent officer and the inquiry officer submits his conclusion with or without recommendation as to punishment, the delinquent is precluded from knowing the contents thereof, although such material is used against him by the disciplinary authority. The report is an adverse material if the inquiry officer records a finding of guilt and proposes a punishment so far as the delinquent is concerned. In a quasi-judicial matter, if the delinquent is being deprived of knowledge of the material against him, so the same is made available to the punishing authority in the matter which is concerned, rules of natural justice will be affected. Professor Ubedes pointed out the concept of natural justice is for many senses.
What is the purpose that you're trying to?
Your Lordship, at least I should be given the inquiry report. Your Lordship, in this case, I was not given an inquiry report. And the
This
proper
notice at 43, 42.
43, Your Lordship. 43 is the letter, Your Lordship. So the notice issued.
This is given by this is during the inquiry,
This is after the inquiry.
after the inquiry.
So second in Soko's notice.
And then this was not accompanied by the inquiry report.
This was the notice, Your Lordship. Oh, yes. No, yes, Lordship. Inquiry report was.
Huh?
There was an inquiry report.
Then how
What's
do
the
you
inquiry
say
report has been forwarded to him? That's mentioned in our affidavit.
The inquiry report.
you have received the inquiry
I
report?
had received the inquiry report. I
Then-
was in jail.
Then what is this judgment is with regard to furnishing of the inquiry report?
Yes, Your Lordship. But adequate, I will be given the adequate opportunity. Your Lordship. I think I was in jail. It was very difficult for me to put my answer there also. That is why my wife had filed this petition, Your Lordship, at page 44.
Allegations against him.
I was absent from duty.
Absence from duty. Where are the allegations?
Page 32, Your Lordship. Page. But hereby required to so under section 65 of the Assam Police Act, read with section 16 of the IPA part 2 and article 3 of the Constitution of India 7 of the Assam Services basically looking and right in the appropriate should not get on. While you consider police reserve office together by DO number testimony to municipal they can was misconduct.
Yes. What is they responding?
Possible. thing is that lordship, one SOCOS was being issued. Then after that lordship, BP number 4 of 23 has been started. Inquiry officer has been appointed. And lordship, in regard to this natural justice lordship, which has been mentioned that para number 13 lordship of the affidavit in opposition. It is a fact that disciplinary authority had informed the petitioner that inquiry in connection with DP 4 of 23 is completed, and a copy of the inquiry report was forwarded to
How
the
do you expect him to participate in a
No, that is true.
proceeding while he is in custody?
And once after that, from the jail, a letter has been received from him to us that we need some time, that we have applied for bail. After getting bail, we'll approach you and file our reply. Accordingly, we have given him 1 month time. He could not, he was not able to obtain the bail during the period of 1 month. See? And after the expiry of 1 month, this appellate order was upholding the order of the.
If you read the inquiry report, it talks about some other FIR, about a missing girl. What is the connection between that particular case and the case of the petition?
Basically, the allegation here in the DP is only indicate the unauthorized absence.
So you see the inquiry report, have you studied the inquiry report, page 37?
Inquiry, yes. This was the brief of the case.
What is this connection?
May I submit it? Case he was an accused. He absconded. He was not present.
Which case?
This was the Kokrajhar PS case number 501 of 2020.
What has happened to that case now?
It is pending trial, Your Lordship. The POCSO case is still pending trial. It is faithful submission, Your Lordship, and we given a fair opportunity to deal with the inquiry report.
What fair opportunity you had absconded without any leave? Your explanation.
At least after the inquiry.
What is your
was in jail.
explanation? What is your explanation in the present proceeding?
I was in jail at the time that went to the
Before you were in jail, you read that inquiry report. The statement of allegation is that you have found unauthorized absence from the police record, Kokrajhar, with effect from 22/12/22, without any leave or permission. Where were you? What is your explanation? What is the explanation that you will provide before the inquiry officer
I am
upon being given an option?
at page 35, Your Lordship.
35.
I have the honor to state that I have been serving at Police Reserve Office, Kokrajhar, as UBC in the period of my service. There is no adverse against. But sir, earlier I had never received notice in time, which was issued on 27th. I could not submit right myself. But lastly, on 25/6/2023, I told my wife about the notice. I could not submit the right of the 27th. So in the period of my service, suddenly I could the IO of Kokrajhar PS case number 501/2022 under section 371, 73, 73 IPC review section 348 was searching to arrest me. I am totally unknown about the fact of the case, hence I was compelled to untrace without information to your honor to safeguard from the office. Sir, my friends of police person, I immediately approached for the Gauhati High Court pending, and it will be take time to finally legal hence until the result of the petition number. That's I have fine family. I'm also very sure of my children. Yeah.
You have read, now you tell us what you have read. What is the?
I absconded, Your Lordship. That's
You
a fact.
absconded.
It's a fact, Your Lordship. I'm not denying it.
Okay.
Absconded.
You have absconded, they have proceeded. You have given explanation. Being inquiry report not submitted, how are you prejudiced?
At that time, Your Lordship, my full submission is I was in jail. I was in jail, Your Lordship, at that point of time.
You were in jail. How did you suffer prejudice that you could not give the explanation? You have already given explanation, page 35. What more explanation are you expected to give?
After the inquiry, because the persons, Your Lordship, the inquiry, the witnesses, Your Lordship, I could have at least replied to the answers, Your Lordship, the witnesses of the case, Your Lordship.
You have admitted that compelled to run away, abscond because of the police case.
That I admit.
Then what is the provision of it?
But the witnesses, Your Lordship, they have failed to establish the fact. Your Lordship, may kindly produce the page 38.
No, in the case of an admission, where is the necessity to say that by independently? You're not resigning from the statement that page 35.
No, Your
No. What is the stage of the criminal proceeding?
pending for evidence, Your Lordship. Victim has been examined, Your Lordship. But the other witnesses are yet to be.
Can't find any way to help you. You have not faced any prejudice. You are alleging, raising concerns of prejudice. You have already explained. And what more explanation are you saying? You are not resigning from the statements. No. That it was obtained under duress or anything.
The point is, Your Lordship, I should have, the inquiry ought not to have been conducted while I was discussing. The inquiry should not have been.
Therefore, we are asking you what prejudice. If it is a case that yes, it was under duress, the statement was obtained under duress, it's a different issue. But that government is not there.
Yes, sir. So I could not examine the witnesses in a proper manner because I was in custody. The witnesses which were examined by the inquiry officer, Your Lordship, I could not examine them properly.
There was some authority that certain circumstances that prejudice would have been caused to you by not examining it.
And for your Lordship, the inquiry report, Your Lordship, may kindly produce.
It has to be examined on a case-to-case basis. You have to not a case that non-examining faced prejudice because XYZ reason, whatever. Where are the depositions are not here?
Positions are distributed.
In the witness,
Yes.
in the inquiry, positions are available here.
No, no, it is, I think, the report,
The inquiry report, Your Lordship.
The inquiry report is there, but
The positions.
the positions will be in the record, Lordship. It's a separate page, Lordship, both page. Office, witnesses, Lordship. And Lordship, one more thing, Lordship, Exhibit 6, detailed report of OC Kukrasar PS. That is in connection with the POCSO case. That has also been taken care in that DP, Lordship. And ultimately, the finding.
come up with any authorities. If you
Yes, sir.
heard Mr. T. Devi and Mr. CKS. Mr. Devi submits that you would like to rely upon certain judgment in support of his contentions before the court. That that the authority not granting him opportunity to examine witnesses, prosecution witnesses during the inquiry proceedings has caused severe prejudice to him, thereby inquiry proceedings, including the order of dismissal by the Secretary of Meanwhile, Mr. CKS Burwan and State Council submits that he came to be dismissed upholding the order of the copy brought in record by the still the month of August. Yes.
I like some judgment, so I want to do this. I relate some Supreme Court judgment.
Yes.
My first contention is that we may be irregular, not illegal, because some process they have adopted, which is in book at the 8990 before Uma Devi. So by that proceeding, we have been selected. Our name is in this panel, so that they get the given the regular appointment. So 53, my lord, Uma Devi's case, 53 clause, 3 tests. One is that there should be a sanction post. We should work there 10 years uninterruptedly without judicial interference. And my lord,
What is the system of creation of posts? How many posts are available, Mr. Chaudhary?
See, during that period of time when these persons were appointed, there was no sanctioned vacant post. In the affidavit also have taken that specifically.
Yeah, why were they appointed? Because put through some interviews.
Lordship, kindly see in the next few documents. In that particular document, I'm just referring to Annexure E, page number 72. In the time of the RAC censure, these persons were appointed, 2 persons were appointed pursuant to the leave vacancy. You should kindly see page number 72 annexure E. Thereafter, they had continued in the service. Because of the fact that on several occasions they have appeared before this honorable court. It's already there in the record. And pursuant to those cases before this honorable court, some stay order was there. And they have continued. Even then, Lordship, they were given the opportunity to appear before the recruitment procedure during the relevant period of time. And they had not participated, they continued with this particular claim for regularization. Because the ample opportunities were given to them, the age relaxation was also given to participate in the selection process. It was not done by them. And on the last time when this particular petitioners approached before the honorable court, and this petition was disposed of, and while disposing of the writ petition, this honorable court has given a direction to kindly pen this order. This writ petition 5046 and 5406 is at page number 125. The direction was given
Which writ petition?
5046 and 5406. The Lordship, page number 125, annexure T.
Which petition you are now referring to?
Yes, I am just referring to 4853 of
4853. Yes.
page number 120.
125. Yes. The direction?
This honorable court, while disposing of the writ petition,
These were filed by the same petitioners.
yes, same petition,
Claim, making the same claim.
same claim. This is the page number 132. Paragraph number 16.
Yes.
Taking into consideration the aforesaid facts and circumstances, this court directs the Ministry of Human Resources and Development to immediately issue a communication indicating the guidelines to be adopted while considering the case of the petitioner in terms of the order dated 5/12/2012. Based on the said guidelines, the NIT signature will consider the case of the petitioner in accordance with the law, and also by taking into aspect that the petitioners have rendered more than 30 years of service and at the verge of their retirement. The aforesaid exercise completed as expeditiously as possible. So that was the direction given by this honorable court, Lordship. And pursuant to that direction, Lordship has pointed out at page number 135. The MHRD has given a direction to the NIT signature, Lordship. And we see at page number 136.
What was the final order?
Yes, Lordship, page number 135 is this order issued by the Undersecretary, Lordship.
No, the direction was issued to whom?
Direction was issued to the Director NIT Silchar, Lordship. And it was, the order was given to the MHRD, first necessary order in this, by this honorable.
All right, then.
Then the MHRD, the concerned Undersecretary had issued the order, the Director. This operative portion is at page number 137. Prior to that, Lordship, 136, paragraph number 5. The National Institute of Technology, formerly Regional Engineering College, are centrally funded technical institutions declared an institution of national importance by an act of parliament called the National Institute of Technology, Science, Education and Research Act 2007. The Board of Governors of each and every institute is responsible for general superintendence, direction and control of the affairs of the institute, subject to the provisions of the NIT's SER Act 2007 and its first statutes. At present, 31 NITs are functioning in the country as institutions of national importance. The appointments to the post, now this is important, Lordship. The appointments to the post of non-teaching post are to be made as per the recruitment rules herein are approved by this Council of NIT SER from time to time. All the NITs are functioning under the umbrella of NIT SER Act 2007 and are governed by the uniform statute and rules and regulations. There are no provisions in the recruitment rules for non-faculty posts that can be implied for regularization of these muster roll workers. In the present circumstances, the NIT teacher is requested to allow one-time age relaxation to participate in the recruitment process, which has been done. Age relaxation may be accorded to the number of years works in the institute with no uppercase on the provisions to ensure maximum number of MR workers are benefited on this provision. Any educational qualification attained subsequent to the initial workers may be taken into consideration. Reservation policy as provided in substitute 12 Statute 23 of amended statute frame under NIT SER Act. Interview shall be dispensed with for all the group B such and such. Institute must ensure that this chance may be given for all eligible MR workers. The direction of the Honorable Court issued in order it is such and such, Gauhati is accordingly complied. So that was the direction given to the NIT lawship. And pursuant to the that direction of the MHRD lawship, we have given the age relaxation. We have allowed the petitioners, the group of petitioners to participate in the selection process. We are saying that
You did not participate.
yes, they did not participate.
You did not participate.
My lord, 2001 resolution taken, 2013 resolution taken, some of the given, but they have not conducted any, my lord, selection procedure from 2018-9 to 2024-3, my lord. Now, this, not that we are on the hearing order will perform, they allowed to continue us. We are holding still the sanction post, but without regularization. My lord, here, my lord, the kindly see the column 2 of page 135. Here, my lord, after examination of the cases, it is understood that the earlier green this ministry, as per the direction of this honorable court, order dated 5/12/2012, conveyed as observed to the NIT at letter dated 25/2013 with the following remarks. The daily wage workers were not appointed. There is a ratio, my lord. Non-faculty and faculty institution calculation as per the revised faculty ratio is 1:1.1. At that time, my lord, what happened when RSC was there? There is excess teaching staff. Ratio was not in 1:1.1. But after that, when ratio is restored, they can do it. And there is 9 excess teachers, 9 excess, my lord, employee. Actual strength.
You approached the court earlier.
Yes.
The matter was disposed of in the
Yes.
direction at page 135, 134,
It's 134.
134. In the specific direction.
Fine.
Ministry was directed to issue communication indicating the guidelines.
Yes.
And thereafter, on this basis, NIT will consider your case in accordance with law, taking into the aspect of the petitioners having rendered more than so and so years. Then this particular notification is issued 5/9,
Yes, well, para 18 kindly see, page 135.
135.
Yes.
Yes.
Para 18.
Yes. Now pursuant to this 5/9,
Man.
this communication was issued by the registrar on the same date,
Fine.
5/9. Now pursuant to that, what is the process? You are required to,
So, my lord, 30 years they have not conducted any selection procedure. If it is so, what if is 2006? They can 2007, 8, 9, 10, 11, 2020, they came. And by that time, the first division is the criteria. And that the condition of the advertisement, some of us has already got repaired and the parts of repairment. So, my lord, they have to arrange this open, my lord, advertisement long back, my lord. Previously, their stand is that their ratio is not restored. There is a ban. That is why, although we have taken a resolution to regularize your service, but that cannot be. After that, my lord, they have, after division bench judgment, they have taken initially some steps. After that, they idle, my lord, and 23 only, 17/23, they suddenly, my lord, advertise.
now Mr. Chaudhary, pursuant to the judgment of the court bench, the guidelines were intimated on 5/9.
Yes.
Now come to your letter on 5/9, 138. The ministry permitted you to go for recruitment. 137,
Yes,
by giving one-time age relaxation, etc., etc.
yes,
But you say that it is not possible to follow because that was already done. Is 138?
yes, Lord. Lordship, this kindly see this first paragraph. It's, it is in pursuance of the judgment dated 23/7/2024 of the Honorable Gauhati High Court in respect to such and such for issuing the guidelines when considering the case of the petition. The MOE by letter dated issued the necessary instruction which is enclosed here for your perusal. The matter along with the letter issued by the MOE dated such and such was placed in the meeting of the Board of Governors of the Institute held on such and such, wherein the board observed that there is no provision for regulation the services of the masterful workers of the institute, and also noted that institute already complied with the guidelines of the MOE. You have already complied.
How can you comply prior to the judgment?
Lordship, prior to the
There is a
Yes.
direction in 134, paragraph 16.
yes,
It was passed in the presence of the council.
exactly. Lordship.
How can you say, did you make the submission
No.
that we had already complied?
No, Lordship, thing is that this, the communication of the Undersecretary Lordship with regard to giving age relaxation.
You first come to the judgment,
Yes, judgment was,
134,
Exactly,
page
Lord.
number 16.
yes,
This was rendered on 24,
exactly,
23/7/24.
23/17.
Right?
Yes,
So the directions will have to be understood, be effective with effect from 23/7/24.
yes,
What is the direction? Ministry to communicate the
Exactly.
guidelines,
exactly,
and you will take all steps to consider them,
exactly,
keeping in view the services rendered for 30 years. Ministry communicates on 5/9, giving you exactly the modus as to how you should perform. 137, the process. 138, you reply saying that we'd already completed.
exactly. With regard to the 137 Lordship, the first one was for allow one-time age relaxation. That was given to the petition. And the age relaxation may be accorded for.
Then you are rendering the order of the High Court redundant.
No, Lordship.
Did you file a review, an appeal, say that we had already taken steps? No further direction was required to
No,
be
the
taken.
direction was, the direction of this coordinate bench was not directly for the regulation. The direction was
Direction was to consider their
consider,
case.
exactly, Lordship. The consideration,
The direction for consideration remains
yes,
until you come and apprise the court that we had already considered. It was passed in the presence of the council,
exactly, Lord.
right?
Exactly.
So the council is expected
No,
to be
at that point
posted
of-
with
no.
the instructions to know that you had already taken steps in that regard, but it was not placed before the court.
No, what
Court has passed its order. Pursuant to that, the ministry has issued the communication. And on reply, you said we had already taken the
No, what has
steps.
happened in this case, Lordship, in this particular, the previous, this
It's
petition,
the,
Lordship.
the previous process by which you had undertaken is not even an issue with the writ petition which was disposed of.
No, in the previous writ petition, Lordship, the issue was with regard to the fact that some certain advertisement was there. So in that particular advertisement, all the direction that was given by the MHRD, that was complied with. We have given the age relaxation.
You read para 16 to 18.
Yes, no.
How have you complied with this? How have you complied with the directions read with the communication of the ministry? As reflected in your communication at 138.
We have taken our stand in our affidavit also, Lordship. Petitioners were given this age relaxation and all the direction that was there by the MHRD,
When?
Lordship. This prior to that, at the time of advertisement, Lordship.
But subsequent to the direction of the court, what steps
Because
have you taken?
during that, when the writ petition was disposed of, Lordship, at that point of time, there was no advertisement. Now the advertisement has come.
So in this advertisement, what steps have you, what?
We have given the adequate opportunity to the petitioners to
No,
participate
but
in the
this is
selection.
not what is reflected in your communication dated 5/9.
Lordship, we are just trying to make out a case that that institute has already complied with the guidelines of the MOE. We are saying that we have already complied with the guidelines. We are not saying that we will not comply. said that we have
The
already.
question
complied.
is not whether you have complied or not. The question is the court has directed you to comply.
Yes, Lordship.
When the
Pursuant to
matter
direction
was,
of this
when the
honorable
matter
court,
was heard, the
Exactly.
direction is there.
Yes.
If you had complied, you should have brought it before the notice of the court that you have complied with it.
No, Lordship, what has happened after disposal of the writ petition, Lordship, the communication was given to the MHRD from the institute. Now the institute, the subsequent communication that we received from the MHRD was with regard to comply with the age relaxation.
How
of
many
these things,
petitioners are here?
Lordship.
How many petitioners?
My lord, previously 67, but they are repaired mostly 20 or 30. I don't know now. It's 25. They're every day they are got repaired.
And how many posts did you advertise?
In the subsequent writ petition,
Advertisement on 23.
in the subsequent.
Order passed 24, and after that communication 24. After that, no advertisement, nothing, my lord. And previous advertisement.
No, this one, 251020. In the subsequent writ petition, they have challenged the advertisement and the appointment of the person.
Advertisement dated?
7/7/23.
That's the earlier advertisement.
Earlier advertised. After that, no advertisement.
For filling up the various posts of NIT. 7723, Lord.
Huh. But pursuant to that, this order was passed.
No, at that subsequent to that, there is no advertisement, Lordship. Because at that point of time, when the advertisement was,
Subsequently, if it is not there, then you take steps to comply with the directions of the court.
no, the direction is with regard to the fact that this person's, Lordship, kindly see the direction. There is no specific direction to regularize the service of the petitioner.
There
We are
is no
saying,
specific direction, but we have been
we are
directed
saying
to-
that as per our recruitment rules, there is no scope for regularization of the service. We have to go by the recruitment rules that is there by the MHRD. And now the MHRD is saying that, yes, you can proceed for the recruitment, but these persons who have been working for last.
So these guidelines have come after the advertisement.
Exactly, Lordship.
So is it not incumbent on the department to advertise this post available?
Because,
What is the status of the advertisement with the challenge in the earlier advertisement? What has happened to that advertisement
No,
selection?
this is with regard to the subsequent writ petition, and these persons have been appointed, Lordship.
Who have been appointed?
This private respondent, this is the subsequent writ petition.
They are appointed.
Exactly.
So
They did not participate in this selection.
or at page 134 at serial number 18, there is a direction.
Yes.
How do you plan to implement this direction at
We
serial
will
number?
plan to implement the direction as per the direction given by the MHRD, Lordship, taking into note of the direction of this.
Kindly read para 18, page 134.
No, we are not filling up the post, Lordship.
Hmm?
We are not filling up the post by direct recruitment, Lordship. They are holding the post, they are continuing with the service in this particular post. We are not filling up the post. We have categorically stated in our affidavit, we are not going to fill up that post. So there is a direction of this onward post. We are complying with the direction. Only thing is that they have to participate in the selection process. They are not participating. We are
But
repeatedly asking them to
The
participate.
selection process, are these posts advertised?
Lordship,
Posts in which they are working?
no, in some cases, these posts have been advertised. Lordship.
Not like, not a
And,
vague
and
reply
that is
like
the
that.
reason why subsequently they filed another writ petition, Lordship, challenging the appointment of some persons. This is the other writ petition which is tagged with this particular writ petition. The persons who have been appointed, they have challenged the appointment of those persons.
The persons which they are working now
Yes, Lordship.
are in respect to what post? Sanction post?
We are saying that at that point of time, there was no sanction.
How are they working?
Because these are all the stopgap arrangement, Lordship.
Okay, then
Yes.
why are you saying that these posts are not filled up by direct recruitment?
No, we are saying because of the fact that they are continuing in service. Since they are continuing in service.
We are asking you a question
Exactly.
that in terms of the direction at serial number 18,
Yes.
para 18 at page 134, there is a direction that you will not fill up the posts where where the petitioners have a scope. Petitioners would have a scope for their consideration.
Exactly.
Which are the posts?
No, with regard to the posts they are holding, presently the posts they are
Now,
holding, Lordship.
on one end you are saying there are no posts.
No, what I am submitting, Lordship, these persons were appointed during the time as per the requirement of the institute, because there was no sanctioned vacant post during the relevant period of time.
Right.
So these persons were appointed because of the fact some leave vacancy, some contingency was there. And in view of that, taking into consideration their services, these persons have been continued because they have approached this honorable court on several occasions. Now they are in before this High Court. Now, what has happened, Lordship, subsequently, when the advertisement was published, they were given the ample opportunity to participate in the selection process. We are saying, since you are continuing in the service, you will continue in
We
the
have
service.
understood that.
As soon as
We have understood that. You have not understood the question of the court. We are saying that at para 18, page 134, there is a direction.
yes,
You say that advertisement is there, we have given all facilities, everything. Now, how have you, tell us, how have you complied with this direction?
would have a
Against
scope for the
respect of which
consideration to be
post?
filled up by directive.
So which posts?
As directed by the Honorable Division Bench in the order dated 5/12/2012, till the consideration is done, the posts where the petitioners would have a scope for the consideration are to be filled up by directive.
What consideration? Consideration for their prayer for regularization. Till it is done, you're not to fill up the post by direct recruitment where they have a chance for being considered. And you say that prior to this order, we have already filled up by direct recruitment. This order has come later,
Yes.
pursuant to which the ministry has given you guidelines. You are not, your answer is that we have already taken steps. This order remains. This order was passed in the presence of the council. Why was it not brought to the notice of the court that we had already taken steps, given whatever is required? Why did you not make a submission before the court that there are no posts available? They're working on without any posts being there.
In the affidavit, we have clarified that aspect.
How can you clarify something in the affidavit which is contrary to your own communication at page number 138?
Page number 138 is there, Lordship, but the page number 138, we have tried to clarify the fact that the whatever communication we have received from the MHRD, we have already done it so far
That
as
we
the
have
advertisement is
understood, but
concerned.
that is prior to the order of the court.
Exactly. Subsequent to that, there is no advertisement.
Subsequent to that, if it is not there, then how do you comply
Subsequent-
with para 18?
Subsequent to that, there is
If
no
you have
advertisement.
filled up the
Yes.
posts
Yes.
prior to the order of the court, then the direction at para 18 remains not complied with. Is it open to the respondents to say that we sit over this order and not comply with it? When the ministry has given you the guidelines pursuant to the orders of the court, yes. And how do you respond to the recent judgments
We are
of the
basically
apex court?
apex court.
There is no denial that they are rendering service. There is no denial that you are extracting service. Yet you are not taking steps for regularization. You may have genuine problems, yes. You may say that no, we have more people than required. You want to take steps for the purposes of regularization. We understand it. But you are comfortably ignoring the direction of the court, asking you to take into consideration these posts, and where a still earlier order of the division bench has been quoted to say that the benefits should be given to the petitioner and the posts in which they may be considered shall not be filled up by direct recruitment. Now, if you have filled up the posts by an earlier advertisement, then you have to satisfy the court that you have taken care to see that the direction at para 18 of the judgment at 134 was taken note of.
This particular aspect of the matter in our affidavit, we have to some extent clarified, Lordship.
Let us see.
What has happened in this case, Lordship, on 8/12/2012?
Where in your
Yes,
affidavit?
Lordship.
Page number?
Yes, Lordship. Paragraph number 16, Lordship. Just take- 181, Lordship.
These are all actions prior to the order.
No, that order with regard to this judgment of the honorable this honorable court, Lordship, the division bench of this honorable.
They have not taken any steps to consider
Lordship,
their
kindly
cases.
see that with regard to the statements made in paragraph 12 of the writ petition, the answering respondent beg to state that the meeting held on 27/9/2013, the resolution was taken to absorb MR daily wage workers in the permanent vacant post as per norm. The institute have time to time published advertisement for filling of various non-teaching posts as per the norms prescribed by the Ministry of Education. Be it mentioned herein that as per the direction of the honorable court by order dated 5/12/2012, Ministry of Education conveyed its observation to the NIT Silchar by letter dated such as. Observation was there by this Ministry of Education. The daily wage workers were not appointed by the institute against any substantive post which was known to the workers when engaged. The entitlement of the non-faculty post for the institute calculated as per the reversed faculty non-faculty ratio 1:1.1 based on the actual student strength for the year 2010-11 is 168, and the total non-faculty post in position are 35 which have been operated in the institute since REC regime, which means that there is 67 non-faculty staff above the entitled staff strength. Further, the ministry by this letter dated 13 June 2012 sanctioned additional 58 non-teaching posts. After a sanction of additional 15 non-teaching posts, the total sanction non-faculty posts in the institute are 226. Now the institute have still 9 non-teaching posts over and above the entitled strength of 35. As per the legal opinion, NIT may place the matter for the consideration of the government, keeping in view the decision. Thereafter, Lordship, the NIT Silchar by this letter dated 5/6/2013 complied with the direction of the honorable court and conveyed that there is no scope for regulation of these petitions. However, considering the age and family condition of the worker, BOG NIT Silchar also given following options to them. The workers will be requested to form a society. The wage, term of engagement, job, etc. will be guided through the society, the existing. So we have done all these things, Lordship, pursuant to the direction of this honorable court.
These are things which you have done well prior to the orders of the court.
Exactly.
Then how can you say that you have done it pursuant to the direction of the court?
No, this page number, this paragraph number 18 refers to the direction of 5/12/2012, Lordship.
Pursuant to that, the subsequent writ petition was there. Where the direction we just read.
Yes, Lordship. The 5/12/2012, there is a direction of this.
No, not 2012.
Yes, Lordship.
24 judgment.
For 24 judgment, yes. Page number 18 and the paragraph number 18 134. That the direction of
If
this
you don't
condition-
have a solution, we'll provide you a solution. All right, heard Learned Council, the parties. We'll pass orders. We have given you enough time to
Lordship,
understand what you should do. In view
Lordship,
of the
here in this
recent
case,
laws.
we cannot go beyond the recruitment.
We don't know what you do. We'll pass orders, dispose.
I'm just referring to the judgments, Lordship.
Pass orders. The judgments are very clear in the recent judgments which have come. Unless you want to distinguish the judgments,
Lordship,
what's
we
the
are
point?
we are on the Madhavi's judgment. It's a constitutional bench.
Madhavi judgment, lot of water has flowed after Madhavi.
Exactly, Lordship. The
Then-
recent judgment of Sukanta Bhattacharya, I can understand,
Then-
Lordship.
then-
But the fact is that, Lordship, there are certain other judgments where it has been specifically mentioned that when the recruitment rules are there, the state court cannot go beyond the recruitment rules because the recruitment rules are very specific with regard to the
All
open
these
advertising.
things you should have heard before the court. When it was there, you did not. You accepted an order. You sat over it. No review, no appeal. You refused to comply with the directions. It's a good thing that no contempt was filed against you. You have to explain that
No,
why in spite of a directions being given,
No, the affidavit will take a stand with regard to that, Lordship. I can understand this.
affidavit, you can't improve on your communication dated 5/9. Can you?
Because 5/9, we are saying that we are complied with the direction of the Honorable
That's
High Court
right. You have
as well as the MHRD, because the MHRD is insisting for the giving age relaxation. We have given the age relaxation, Lordship.
prior to the order.
Because the advertisement was there prior to the.
So what steps have you taken prior to the order, subsequent to the order? That's the question we are asking you for the past 20 minutes.
Subsequent to that order, we have
You
not
have not
taken.
taken anything.
Exactly.
That's the whole issue. Why have you not done so? And how can you improve your case by filing an affidavit? You have not done so.
So we have clarified because the
You have
communication
not
was there.
clarified, you simply don't want to do it. You simply don't want
It's
to
not
do
like
it.
that, Lordship. We have given them the
You-
ample opportunity to
What
participate in the
ample
selection process.
opportunities? You are extracting service from a man for 20 years, 25 years. And then you say we are giving you ample opportunities to participate. What is
Because
this?
the recruitment rules, we cannot go beyond
Recruitment
the
rules.
recruitment rules.
Don't permit, then you have to take necessary steps to get it amended, modified. There is a direction there.
Because if the
This direction, you've been sitting over this direction for the past 2 years, 3 years. What have you done? Mainly because no contempt is filed. You are refusing to comply with the direction. You are going back to a stage where the directions, prior to issuance of direction, you say you already complied. That you did not bring it before the court. You should have brought it. Then we are already complied. There's no further way to comply. Say that. Not done it. You're the NIT, you're a public
No, Lordship,
institution, you're extracting people, the services from the people. What are you doing?
it's not like something,
Tell me one thing, who employed these persons on temporary basis?
because that was previously at the time
Who-
of the,
who employed?
yes,
Who employed?
at the institute.
And the
Exactly.
people who were at the helm of the institute, did they not know that there were no sanction posts? Have you taken steps to proceed against those officers and staff who had given this employment, which according to you was not authorized?
No, that was not done, Lordship,
Then?
but the exigency of service was also there, Lordship, because at that point of time, shortage of staff
So
was also there.
exigencies of service was there, can it continue for 20 years?
Otherwise, it otherwise not done, Lordship. The thing is that since it has been, this process has continued for a long period of time. But the fact is that, Lordship, we cannot go beyond the recruitment rules. When the recruitment rules is saying about the open advertisement.
Recruitment rules, you have been given a guideline, you have been asked to take, you have not taken a decision. That's the whole point. What you can do, what you cannot do is a different issue. But this 5-9 communication says you've already given it in 23.
Yes, sir.
You say you have complied with the directions of the court of a judgment passed in the year 2024, in the year 2023. Is it possible?
No, the direction was given to the MHRD, Lordship. The MHRD formulated certain guidelines.
Direction
Yes.
is not on, you read the order again. We have
Exactly,
explained
Lordship.
to you.
Yes,
Always
yes.
heard, we'll pass orders. Yes.
Lordship, I am relying on judgments, Lordship.
You give your judgment.
Yes, sir.
Yes.
Let's.
Yes. What has happened here?
Will the records are not used.
As per direction. As per direction of this court, we allowed, your lordship allowed to inspect the records.
Yes.
Now, records has been looked into by my junior. They made a note of it, of the records, and we find some. See my lord, please. Please see my lord, in Golaghat district, Golaghat no records, Majuli no records, Kokrajhar no records, Gwalpara no records. 9 record, no records, Karimganj no records. Then Kamrup also no records, Dhubri no record as to paper publication. Sonitpur no record as to required documents, no outcome of verification process. Morigaon no paper publication, no proper document requirement, no records of documents submitted. Please see Jorhat minor. No paper publication stating recruitment of document, requirement of document which is mentioned in the checklist, no verification report of the executive engineer. Now see Kamrup, no paper publication, no enquiry report, no proper record maintained. Sifsagar minor, no date mentioned in the enquiry report, paper publication without stating requirement of document which is mentioned in the checklist. Same requirement was not informed to the petitioner which were appointment letter issued by department, joining letter, salary related document, any other document issued by department. If you see Hailakandi,
serial number 14, paper publication with a requirement of document. Noted that petitioner did not produce any service-related document to substantiate engagement in master role worker. Now, Dibrugarh, re-verification process was not published. Darang, no record as to when paper publication released and what documents are required.
What was the direction passed by the coordinate bench earlier?
Coordinate, oh yes.
Which page is it?
No, no. Coordinate. Just 2 minutes.
They were
Judgment is,
This is at page 534.
yes. 534. I deeply obliged. Please see my lord at page 36, 536. Lordship got it? As this
Yes.
court has observed, a report annexed with the additional affidavit is of the year 2008. This court is of considered opinion that without entering into merit of the case, it would be in the interest of justice dispose of all the writ petition by directing the respondent authority in the Water Resource Department to have a re-verification with regard to the claim of the petitioner as to whether they were appointed after 1/4/1993 and have continuously been serving for 5 years till 24/1/2001. That such exercise has been done and completed within a period of 6 months from the date of receipt of certified copy of the order, and thereafter, on completion of the exercise, petitioner shall be intimated with regard to the outcome of such verification. Here, my lord, our case is that you have not done the exercise which has been asked to do by the coordinate bench, by the learned single judge. My lord, it is a fact that this outcome was not given. What was to us, intimated to us. How can they do it, my lord? Your lordship has seen what verification they have done. What verification they have. So that is why I made a prayer before your lordship that why it doesn't go again to them. Let them freshly verify it. Absolutely no problem. And they agreed in 13/3/2026 order. Please see the order passed by this court on 13/3.
Are you serving?
No, we are not serving. There's no problem, my lord. I'm not serving.
And even if it is sent back to the department, same thing will happen. In all these records, my lord, they could not produce a single document regarding their engagement. And whatever my brother is saying regarding no record means they could not produce any record regarding their engagement.
Is there
It can
anything in
be-
the record?
Yes, I have
There
seen
was
that
nothing in the record.
those people, they appeared before
Yes.
the inquiry committee and they could not produce any record. Therefore no record. It's not
No.
that nothing is there.
There
But
is
I
no
have
paper publication.
paper publication.
Yes.
I have got original copies. I
Where
can
is
produce
that?
it.
My lord, ultimate end of the day, these are not intimated to us also. You
This
cannot
part-
do
this
that.
part,
It is
of
not
course, my lord,
intimated.
there is no dispute that this was not intimated.
Then,
to
my
them.
lord, without intimating to us, how an action can be taken by the authority, my lord, saying that you have gone to the court. Now again, you may go to the court. Now don't do it. Otherwise, we'll go and proceed with the criminal case. At least they should inform us, my lord. They take an action against me. Absolutely no problem. Please inform the outcome. What has happened to that verification? My lord, the specific order was passed by this court. Intimate to the petitioner. Well, we have no grievance, my lord. Let a verification be done. Let them intimate.
Well, verification to what effect? For
Yeah.
regarding your appointments?
My
Is it?
appointment,
That whether
yes,
they
they
were
were working or not.
on 1/3/1993.
That's
What
only.
record would be necessary?
My record is necessary. They will have whether master or worker. They should give a notice to us in each of the appellant. Then they should ask, where is your letter? Please produce it. Where is your document? Where you have served? This they should have asked. And ultimately, if you don't find satisfaction of my particular answer,
How many writ petitioner?
then I'm sorry.
How many writ petitioner?
How many? 1810.
1800.
181. This was before the court. I think there were less. It is less now.
How do you propose to verify?
My lord, in earlier occasion, each and every district we made paper publication. Original papers are there with me. The day also I produced it before your lordship. The original papers were there. They were asked to appear before the committee. A committee was formed. They were asked to appear before the committee. They appeared before the committee. They could not produce any valid document. This is the my lord, records available here. That Lordship had expressed an opinion that whether in fact any exercise was taken up. Therefore, these records were called for. And Lordship, I find the names of the persons are there who had appeared. It's not fictitious. Whatever was alleged, that it is all fictitious.
Sorry for doubling my
They
learned friend.
appeared.
I'll make it short, my lord. If your lordship looks into one record of Golaghat, Majuli, please see record of, I'm sorry to trouble this court, my lord. Please see the record of Majuli, my lord. See the record of Majuli. What is there in the Majuli? See, is what is there. You can share me also that I can tell the court.
Majuli,
No,
there
nothing is there because
Majuli, there is.
then, my lord, why I will make
I'll
this.
do one thing. My friend has given this list. I'll as per this list, my lord, I'll produce all this in the form of an affidavit.
Produce it. But this form of an affidavit, but
I
is-
enclose the documents, my lord. It
Huh?
is there, my lord. Majuli, okay, it may not be there, but other district I have myself. seen, my
Golaghat,
lord.
Golaghat,
The list
please
of
see
Golaghat.
Golaghat, Pokraja.
no, these records are not there means, what is the indication of that? Is it that no inquiry verification was taken or an attempt was made but nobody appeared?
Nobody appeared.
But if nobody appeared, there has to be an endorsement that nobody appeared. Is it available in the records that the committee has given a finding that no one appeared?
With reference to subject of, I have to honor to inform you that as per the instruction, one advertisement was published in local newspaper for submission of related documents from the persons whose name were included in the list of Honorable Gauhati High Court order within 7 days from the date of publish of advertisement for re-verification. After publication of the advertisement local newspaper, no any petitioner has submitted application and document against the WPC number so and so at Majuli Water Resource Division. The report regarding the chief engineer's letter after publication of an advertisement local newspaper re-verification of document, no any petitioner has submitted an application. But he appeared.
Then please go because it was checked by my learned friend. Please look into thereafter. What
Right.
is it? However,
Want to take your lordship to all this, but otherwise, lordship you can very well go through this. All these petitioners, they appeared before the committee and they could not produce anything. Even if it is sent back to the government again, same thing will happen. They cannot produce the documents. They cannot produce.
What is there? What was that you wanted to show?
no, I am so good there. Golaghat, please see Golaghat. Golaghat. Please see Golaghat.
But in reference to the subject in letter cited above, I have the honor to inform you that no any record found in this division in support of the appointment of persons as master role, any other similar category after 1/2/1993 as listed in the Honorable Gauhati High Court's order dated so and so, and the list of Honorable Gauhati High Court case number so and so, the following persons belong to Golaghat division whose appointment records a record is also not available in the division. So serial number 2 in the list is Jyotendra Puli. So in this regard, it is to be worth mentioning here the jurisdiction of Golaghat Water Resource Division is under Jorhat Water Resource Division before May 2023, and Executive Engineer Jorhat Water Resource Division has submitted information by letter number so that there was no any master role worker.
What is your claim? What was the claim before the court earlier?
Earlier round of
What is
Yeah.
what was the
Well, there was
challenge?
there was a notification by the state. That notification that who has worked more than 5 years of service, continuous more than 5 years, so they should get the benefit of the employment. Now this was working. Now immediately after that period over there, they decided not to retain us. Then we said that we are covered by that, so why we should not be retained? So that led to the litigation, not 1, 2, 3 litigation. Then thereafter, what we came to the court, last round of litigation, we said whenever there is a post which there is an advertisement for this post, first preference should be given to us. Now we came to this court and we said the list was prepared by chief engineer of water resources department. The petitioners who are before this court, the name appears and they, how many years they worked, that also indicated. That list we annexed with the writ petition. In page 471, we annexed that.
In this readings
Yes.
also.
Yes, and we said these are prepared by the chief engineer. These are the person who have been working. So what do you want to say on this? They said, no, it's not correct. How this can be prepared by chief engineer? Who is chief engineer to prepare it? Then he could say, okay, what we are doing, we are sending again for re-verification to this department. Let them find it out, right? Whether this person was really working on it. That is why that order was passed.
Yes, you tell us what steps will you take?
Minor.
What steps are you going to take to resolve
Minor.
this issue?
It is not their case that they had produced these documents and these were not.
Where is that list in the present proceedings?
Yes.
There,
Page 471.
471.
Yes.
Statement in respect of work charge master roll work.
5 years of continuous service on a different division, which is prepared by chief engineer Gauhati. So these are the list. $1,207%. Total at 529. This year 529. Up to 529.
Why do you say this is prepared by the chief engineer?
This was prepared. Statement
Where
by
is-
chief engineer Gauhati. If you see at page 471, that's what it says. Statement in respect of so and so completed 5 years of continuous service as on so and so on a different division, which is prepared by chief engineer. No, what I'm saying, they said that no, this may not be prepared by chief engineer. This is what they were saying in the court. Then you verify it.
This minor, they should have some document.
And in respect of your appointment, or is there any document that you would like to rely on?
Nothing, my lord, not in this proceeding and in the inquiry also, they could not produce any document besides the Aadhaar card.
How were you appointed? How was the salary or wages given?
So that is why the court has passed that order. That is why the court has passed the order. You look into it.
No, but
You
then
find it out.
assuming we remand it back,
Yes.
where is
No,
the guarantee
my
that the
name-
same thing will not happen?
No, my lord. If they have not done the exercise, they have to do the exercise through court's order. We are on that mind. If they have done the exercise, if they have given a chance to us, then there's the end of the matter. There is no grievance against them.
That is their claim that we have done it, but none happened.
No, they
None
have not
appeared.
done it.
The-
That's
My lord,
why.
all these records, my lord, names are there.
No,
Who
let
all
them-
appeared before the
No,
committee?
you just find an affidavit.
Yes,
then
I'll
who has
file, I'll
appeared?
file all these,
Who has
all
appeared,
these
you file
records,
an
my lord,
affidavit.
before the court.
Who has appeared?
No,
My lord,
you
names are there, my
you
lord,
do
who
one
are-
thing, you
and
file
what
an
they,
affidavit,
my lord.
file an affidavit.
Fine.
You prepare this chart, give an indication that this information is relatable to so and so record. If required, we use it. Otherwise, I don't think the
To
entire.
say that no exercise was taken is not correct, my lord. My lord, I do agree that it was not informed because maybe they thought that all these people who appeared, they could not produce anything, so end of the matter. But they did not comply that part of the order. But it's not that no exercise was taken. I have checked up, my lord, all the persons who appeared before the committee, their names are the committee duly formed.
All right, then you file the affidavit on these
One
records.
affidavit I have filed,
Mr.
anyway,
Das?
I'll file another affidavit, my lord.
Mr. Das,
Yes.
I think let them file it.
No, that is the order your lordship has passed on 22/1
One affidavit I have already filed, my lord.
2025. See the order of this court, man.
No, we are aware.
Yes.
Assuming we accept your prayer and we remand it, what happens? Net result would be the same.
No,
that
it cannot. That result may not also. If they
we
have
know,
done
but
exercise.
therefore, in order
proper-
to
No, what? My
arrive
lord-
at this conclusion,
My lord, what's the procedure? You have done your homework, you have done your exercise, intimated to the petitioner.
see,
This is what we have
if you,
not
if you
found.
come to this order of 13.3, you are referring to 13.3.
No,
which
no,
order?
no. 22/1/2025.
2125.
Yes. My lord, the petitioner agreed by minutes of discussion arrive at the office so and so whereby there is a finding reflect a minor upon review or re-examination of verification document submitted by the petitioner pursuant to direction of this court by the order dated 5/3/2024 passed in WPC 5823 of 2021. Certain documents are found to be not genuine and therefore cannot be admitted accepted by department. Consequently, said committee decided to hand over the cases of person pertaining to the said matter along with those documented criminal investigation, a sample of further investigation. It is submitted by so and so that court while demanding the matter department for re-verification of document specifically directed conclusion finding on department pursuant to re-verification should be informed to the lead petition. This, however, was not done. Department was directly to re-verify without any concrete finding has filed a case in terms of direction of this court. Petitioner were required to be informed about the conclusion arrived at by the department. Being aggrieved, the present writ petition has filed. The learner submits that there since the conclusion arrived by the department were not made known to the petitioner, which is contrary to direction issued by this court, the investigation conducted by CID should be stayed during the pendency of the petition. Now, I have seen the respondent represented that the respondent so and so
So then you come to the order of 13.3,
13/3.
26.
13/3.
Yes.
Yes.
Then come to para 7 of that order.
Para 7. For the court to direct re-verification, thereby finding on the fact verification are either not undertaken or undertaken, but not in terms of direction contained in the order passed in WPC number. Therefore, this court directs that the respondent department produce all relevant records pertaining to verification undertaken in respect of repetition of perusal of this court on the next date fixed. So now, when it was fixed, your lordship was given an opportunity to look into the records.
So therefore,
for inspection.
we want them now to bring it on record so that if we come to the finding that yes, the verification was not done in a manner that was directed, issue direction. And if the verification was done but not intimated, then also we see what directions can be issued.
Apparently, appears that it was not intimated.
That
It is
they
not
have,
in-
That
they have
they have
way, that way,
conceded
that
that
way.
it was not
I have not
intimated.
seen anything.
They have not indicated. But the question is whether the re-verification was done or not. Let us see what is the process they have
No,
adopted.
that's true, man. Definitely. I'm not saying. For a minute also, I am not saying that your lordship cannot pass it. What I am on is that there were two parts. One is to carry out the verification. Second part is to implement.
Right.
So they could not have gone to the extent of passing that order for lodging a criminal case. What they could have done it, my lord, verification completed, intimate to the petitioner who are before the court. This is what we have not found. So this is what reply we have found.
And what is the stage of the criminal matter?
Nothing. It doesn't say nothing.
Investigation.
That I don't have specific.
Or is it is not gone ahead?
All right, heard Mr. D. Das, Senior Counsel, assisted by Mr. K. Mohammed. Studying PHE,
What is?
Water Resources. In deference to the earlier orders, the relevant records have been produced and upon being permitted by the court, counsel to the commissioner and also perused the same in the presence of the planning council. So, according to the petitioner, that there is no record in respect of great number of districts, and therefore it has to be concluded that there was no verification done in terms of the order dated so and so passed by the coordinate bench in WPC number so and so. Per contra, MS Chakrabarti submits that the record revealed that there was no presence of the petitioners, although advertisements were issued and a committee was set up for undertaking the re-verification.
Few districts, not all.
In some of the districts. The learned council therefore submits that she would like to bring on record by filing an affidavit as to the districts, as to how the verification was conducted and as to whether the petitioners had appeared before the verification committee set up for verification in those districts. Submitted that the records are available. She craves leave of the court to bring it on record by way of an affidavit. Where a prayer made is granted, that this affidavit be filed and copies be served on the council for the petitioner within
And after the vacation.
in 3 weeks.
They said a few district, what will happen to other districts?
Other, I'll give details.
Let's see
Who all
what comes
appeared?
in the
I'll
affidavit,
give
let us
by
see
name
how
now.
release this matter again for 27th July. 27.
Man.
Interim order passed earlier, if any, will continue.
My assumption is that the qualification which is required, that was already passed 2 years back. Lordship, I have statement in my executive reply. Lordship, you kindly see page 56, paragraph 4. Page 56, 55. Very Lordship. From third line, states and submit that the advertisements were published on 28/11/2023 and the last date of receiving the application was fixed on 12/12/23. Whereas the petitioner passed his SLC examination in the year 2021 and she had the requisite qualification for applying to the post of Anganwadi worker at the time of publishing.
Who has placed the judgment shiny CJ?
Passed the princess of the examination in the year 2020 and she had the requisite qualification for applying to the post of Anganwadi worker at the time of publishing advertisement and while filing the.
There is no one appointed.
No one appointed.
Why?
The interim order is yellow, not to fill up the post. After passing the SSLC examination, immediately she obtained admission in Walfire College to pursue BA course. And at the time, neither there was any advertisement for the said post, nor she ever thought to apply for the said post. If the interview was held on 4/6/24, the petitioner had already appeared in 6th semester of the final examination.
What is the role of an Anganwadi worker or a helper? What is the job profile?
Basically, they Anganwadi center pilot. where it's a preschool, my lord, where the children, toddlers, my lord, they attend the school. And my lord, they are taken care of.
It is a preschool.
Preschool.
So there are teachers or it's being taught by the Anganwadi?
Anganwadi is helper and worker, my lord, they only. The play school basically. Where even they are given this meals and all that. Twice and everything.
So what is wrong if a person slightly highly educated comes,
This is not
except for the
this is not about my lord highly educated. This is about my lord
vis-a-vis
the condition of the my lord. First is our notification and second is the condition of the my lord advertisement. And this was brought to us, my lord, we did not know it. So in complaint, my lord, it has come before us. So we had to address it. We could not have, my lord, just, my lord, put it under the carpet, my lord. So we inquired into it and we found that yes, the complaint that's been placed before us is correct. The petitioner was a regular student at the day when this advertisement was made. And during this examination whole process, she was a student. That is correct. That is not incorrect. And my lord, because of this, the notification of 2019 and our advertisements condition, my lord, doesn't fulfill the criteria. That is why, my lord, we have to act upon. Otherwise, my lord, we selected her. If we, my lord, just
who complained?
President of the management committee of the center.
How is he concerned?
Some record in their affidavit. Page 51. Since that if someone has to leave his studies in the middle to apply for a job of lower qualified job.
my lord,
I have also
my lord, even recently I have come across one honorable Supreme Court judgment last week only, my lord. That
I have made that statement, Lordship, in my reply is 57. Kindly see.
What have you come across?
my lord, that honorable Supreme Court laid down that, my lord, a higher, my lord, qualified person should not compete into a position where lower, my lord, this education qualification is mandated, my lord.
Please it.
How much higher? I first hired
Please
secondary,
it.
then I was pursuing. The meantime, advertisement come. I applied for that.
My lord.
Please it.
My lord will fix the matter or my lord after work sometime, my lord.
Tomorrow. Tomorrow. The request made by the State Council, Mr. Radhav, enabling him to please deliver the export list release tomorrow. Yes. Thank you.
Yes, my lord. Model number 7 and 8 appear and not file any affidavit. And the 3, 4, 5, 8, 9, they have filed the affidavit.
You're claiming what, pensionary benefits,
Oh, my lord. Insurance benefit.
insurance?
Yes, ma'am. My lord, my husband.
Who's the nominee in the insurance?
Yes, my lord. The father was the nominee of the insurance, my lord. But I am the petitioner, wife and son.
So, but the insurance will be governed by the contract.
No, my lord, only that is not. They are claiming only that point. They are issue only one issue that they are the nominee. That should they should get the insurance benefit for them, because we are the legal here of the.
You
deceased
may
person.
be, but the nominee will get the
No, my lord.
amount as per the contract. This is
No,
not
my lord,
pension.
Apex Court is very much clear in this respect, my lord. I am relying on judgment. Saurabhati Devi and Usha Devi, my lord. This, yes, my lord, Apex Court clearly stated, my lord. Last part, the para number 12 in last part, my lord. Here it, last part, my lord. Moreover, there is one other strong circumstances in this case which disclose us from taking a view contrary to the decision of all the High Court and accepting the view expressed by the Delhi High Court in the recent judgment delivered in the year of 1978 and in the year of 1982. The Act has been in force from the year of 1938, and all along, almost all the High Court in India have taken the view that a very nomination effect under Section 39 does not deprive the heir of their right in amount to payable under a life insurance policy. Yet the preliminary has not choice to Parliament has not choice to make any amendment of the Act in such a situation unless there are strong and compelling a reason to hold that all these decisions are wholly erroneous. The courts would be so to take the difference view. The reason given by the Delhi High Court are unconvincing. We therefore hold that the judgment of the Delhi High Court in Sinha cases, Supreme Court, and Mrs. Uma Sagal cases, Supreme Court, do not lay down the law correctly. They are therefore overruled. We approve the view expressed by the other High Court on the meaning of the Section 39 of the Act and the whole that a very nomination made under the Section 39 of the Act does not have the effect of the conference on the nominees and benefit interest in the amount payable under the life insurance policy on the date of the insurance. The nomination only indicate the and which is authorized to receive the amount on the payment of which the insured get a valid discharge of its liabilities under the policy. The amount, however, can be claimed by the heir of the assurance according with the law of the succession govern them. So, according to succession, my lord.
This is your answer.
Yes, my lord. According to succession, we are the.
So, but mayor making a claim under succession will not give you the right to succession. It has to be decided by an appropriate court of law.
Yes, my lord.
But till
But they
then,
are claiming only the nominee, only that point they are claiming.
the judgment which you are referring
Yes,
gives you the answer.
yes.
The court is of the view that mere inclusion of the name in the nominee does not disentitle
Yes,
the legal heirs from making a claim, but under the law of succession.
yes.
But the corporation can discharge its liability by paying the amount of the nominee.
Only
You
the-
make a claim against the nominee.
My lord, the last part of the judgment. In view of the above, conclusion, the judgment and decrees of the High Court, the first appellant court and the trial court are liable to be set aside.
That's right.
They are
What is
accordingly
challenged
set
here?
aside.
What is challenged here is the claim made by the by the legal heirs
Yes.
have been set aside, have been turned down by the courts below,
No, my lord, that is allowed by the apex court.
the lower courts, against which the
Yes,
appeal was filed.
lower courts are turned down.
Yes.
Yes,
So therefore, the court said that nominee being there does not disentitle the legal heirs.
yes,
But claim of the legal heir is to be raised through the law of succession.
yes, my lord.
You raise it.
Already I have filed a petition,
Ah.
but they are not allowed me and they are going to disburse the amount in favor
You
of them.
You get
That's
your,
why I am coming here.
you get your orders from the court where you have filed the petition. You have filed the petition under succession.
No, I am not, till now I am not filing the
Then
petition
why?
under
This is a
succession.
matter of evidence.
Yes, that is a matter of evidence.
Then what writ are you seeking from the court?
I am coming
What
here
direction you are
only
seeking
for
from
that,
the
my
court?
lord. Till that they are not released the amount because they are going to release the amount in favor of them.
You get,
Only for that point, that issue.
you have to satisfy before a competent court that you are the legal heirs.
Yes.
And you have a claim
But
under
that point,
law of
because they
succession.
are not object at all. They are filed the affidavit, they are admitted.
Hmm.
I am the legal here.
The judgment that you're relying on,
Yes,
is it a proposition that the amount should be released to the legal heirs instead of the nominee?
yes.
Show us which line, the judgment.
That is, I should file the case in the appropriate court. That is, but here I am coming only for that, my lord. If the amount is released to them, then my lord, my
You
matter will be
take
effective.
appropriate protection from that court where you are going to file your petition.
Yes, my lord.
That court will be
In
competent to
between,
give you protection.
Kindly protect me, and I am going to file.
No,
it.
no, we are not protecting you because you will proceed. You are intend to file in an appropriate court of law. You have not filed any petition
No, till now, no.
till now, so you intend to file.
Yes,
Right? Once you intend to file, you make appropriate prayers before that court. We can only observe that if the amount is released, the same will be subject to such orders passed by the court in an appropriate case under succession law,
Yes.
entitling
Yes,
your claim.
yes.
That's the only observation we can make. Who's for the LIC?
LIC, I mean, they are the insurance company.
Oriental insurance.
Oriental. Insurance.
Oriental, okay. Oriental, who's there? Who's the insurance? Who's the
They are not
counsel?
repaired, my lord.
Hmm?
After receiving the notice, they are not repairing the report.
They are not appearing.
No.
There must be some counsel representing Oriental. So we'll make that observation, close your petition. Is that good for you?
Kindly protect me.
Protect you in what sense?
Under-
You have placed the judgment
Now they are ready to release the amount, my lord.
to the nominee,
Yes,
right?
yes.
You do
But
not
nominee
dispute,
is not entitled to the whole amount, my lord. As per law,
but
successor
you
law.
have to make a claim.
Yes.
You have not made a claim as on date.
They are claiming, my lord. They are
No,
filing.
you
No,
as
no,
a
I am
legal
not
heir.
going to file this suit, but I am claiming in the insurance company
No,
that
no,
we
you
should get my
can-
share.
can claim, but
But insurance not allow my petition.
because an order of the competent court would be necessary.
Yes, I am not going to appropriate court. That's
Ah.
all right.
Ah.
But I am already representing the insurance company. I am claiming them.
Insurance company will go by the contract. In the contract, there's a name of a nominee, so they will release it.
Yes.
Why should they enter into a dispute between legal heirs and nominee?
My lord,
only nominee will not entitled to get the amount, total amount.
So that
They will get the some share. I am ready to give their share.
no, you are ready to give. It comes
Yeah.
only when you receive the amount.
Yes.
You are not a nominee, so my amount will not be released to you unless there is some order of the court. That order of the court must be rendered in a proper proceeding, which you are yet to file. Right? So insurance, Oriental Insurance. One of Oriental Insurance. You call up after a while.
Yes.
After a while. Huh? Okay.
Yes, four petitioners are claiming compassionate family pension. Petitioner number one is the wife of the late husband. Two is the minor daughter. Three and four are the parents of the late government employee. The private respondent number five, the first wife, now came to know, and she has also agreed that she will maintain three out of four, and she will give the share as per their agreement. So as per their stand, paragraph 10, 12, 2016, 10, 12 and 16, the matter may be disputed. Paragraph 10, page 38. The other members who are mentioned as legal heirs in the NOP are also entitled to share of the pension amount.
38.
Yeah, page 38 of
Hmm.
their affidavit. Paragraph 10,
Paragraph 10.
the relevant portion I am reading.
This is an affidavit by
The private was 5.
respondent number 5.
She has agreed. I'm the first wife.
You are the first wife.
Fine.
Where is that?
On the last sentence, of course, the other members who are mentioned as the legal heirs of NOK is page 55, are also entitled to some share of the pension amount under CF scheme, and the answering respondent is ready and willing to give them. Then another paragraph, paragraph 12.
Yes, I have admitted that.
You have admitted.
Paragraph 12 also.
Heard learned counsel of the party. So the state petition filed by the petitioner for the claimed to be the legally wedded wife of late Ranjit Kumar Ray. Petitioner number 2 is the minor daughter, and petitioner number 3 and 4 are father and mother.
Yes.
Stop. The petitioner was serving, the late husband of the petitioner was serving under the Assam Police and was posted in the office of the commandant, 9th Assam Police Battalion, Nagaon. Stop. Unfortunately, the petitioner died in harness on 8/2/2020. So, the petitioners approached the department authorities for release of pensionate family pension and other service-related benefits.
In terms of notification, 14/9/2007.
Page number.
Page 25.
In terms of notification number 14/7. 14/9/2017. So, the counsel to the petitioner refers to the next of kin certificate dated 21/9/2022, which is enclosed to the writ petition to support the claims of the petitioner that they are the legal heirs of late so and so. So, while the claim of the petitioner was under consideration, the private respondent number 5 also staked her claim, stating that she was the first wife of late so and so, and therefore she is entitled, she's the lawful person to receive the benefits of compassionate family pension. So the pleadings are exchanged between the parties. In the affidavit filed by the private respondent number 5 at para 7, there is a specific averment.
10, 12 and 16.
Paragraph
10,
10,
12 and 16.
that the respondent 5 is entitled, the petitioners are entitled to
Petitioner
a share
2,
of
3 and
the
4.
pension under the CPF scheme. And the respondent number 5 is ready and willing to share it with them. So these averments are extracted below para 10, 12 and
16 last
16.
Last sentence. By answering the respondent duly undertakes that she would take care of other legal errors.
So the learned counsel for the petitioner submits that in view of the averments made in the affidavit, the writ petition can be closed, directing the respondent authority to release the claims in favor of late so-and-so towards compassionate family pension, and upon the same being released, the respondent number 5 should be directed to share, give the proportionate share, the writ petitions.
All not all, 2, 3 and 4.
Yes, there are Mr. D. Bora.
Mother, father and minor.
Now the NOK from the
Entered.
Then
Only the petition number 1, Lord. Except petition number 1, others are.
petition number 1.
Ah. The learned counsel for the state submits that as per the legal year certificate,
Page number 55 below.
in view of the statement made by averments made in the affidavit of respondent number 5, the petitioner appears to be the second wife, and therefore the entitlement of pensionary benefits stand would be required to be released to the respondent number 5 as also petitioner number 2, 3 and 4.
Yes.
So under the rules. The question of share of pension between the legal heirs and meanings of deceased government servants has been considered by a full bench judgment of this court, rendered in the judgment. Full bench
Miss Junova Bibi.
Genova BP reported in where the court has already laid down the procedure in which the pensionary benefits are to be shared. Next up. The averments made by respondent number 5 which are in the paragraphs extracted clearly indicates that the petitioner, the respondent 5 being the first wife, upon receipt of the pension, she is willing to share, make the proportionate share to the other claimants, including
she has already
petitioner.
received.
So,
She has already receiving money from the date of
receiving.
Yes.
You're receiving it.
Well, I am receiving. So,
It
may
is
not accept,
submitted
may not.
that the respondent number 5 is presently receiving the pension.
My lord.
In view of the specific averments made in the affidavit and in considering the submissions made thereto, the writ petition stands closed. Permitting, writ petition stands closed without any further direction, save and except that the respondent number 5 will abide by the averments made in the affidavit filed on so
In
and so.
respect of not petition number 2 to 4, not accept petition number 1.
That you can't do. That you can't do unless you make a statement that she is not the wife.
My lord, I have made the statement. I have made, and I have undertook to share my lord with the application number 224 only.
I am also wife, my lord, but I am second wife. Subsequently, I was same certificate is there.
I have made the amendment that she is not entitled, as her marriage was null and void.
He has already received my lord provisional BCRG, deep salary, yes.
Who has
amount,
received?
Yes.
I am receiving.
Page 50, page
The-
56. The list
Needless
has-
to say that the claims of the second wife vis-a-vis the first wife have been clearly delineated in the judgment dated so rendered in Favigam. Therefore, the laid down name of petitioner regarding the pension and other service benefits. That view of the matter, the petition stands, goes disposed. The orders intend to stand vacated.
On page 56, that may be reflected. She has already received what are the amounts? Maybe reflect page 56.
We have stated that you will be governed by the judgment rendered in Favigam. That's
Respect
all.
other petition.
Other, they have already admitted.
File regarding CRG or
Whatever is there, they will share.
My lord.
This is item number 19. 19. Huh? Yes.
Obliged.
Huh? Yes, Mr. Das.
Facts. But I just want to place, the judgment. Not facts, normally facts are placed in the judgment. One judgment of this court which connects is 6452 of 2020. 6452 of 2020. Chiranjeev Das versus State of Assam. And there are other connected copies.
Yes.
Excise matter. Judgment was delivered by this court. 1912-2025. Second page. Now, to cover March, para 33. There is a subject matter issue.
33.
33. Therefore, upon proper analysis of the judgment discussed above, it is seen that in all the judgments on the facts of each and every case, it is seen that the inquiry conducted earlier either concluded in favor of the delinquent officer, thereby the inquiry officer conducted charges are not, or that there was no sufficient evidence to sustain the charges level against the delinquent officer. In all this matter, the disciplinary authority in each of these cases disagreed with the conclusion arrived at by the inquiry officer in favor of the delinquent officer. In other words, the conclusion arrived at by the inquiry officer did not appeal to the disciplinary authority, and a consequence thereof, de novo of fresh or second inquiry was initiated. And under such circumstances, the coordinate bench of this court, as well as apex court, in so and so, considered and concluded that the second and conducted was not permissible. So, my lord, what is our case? Whether this case can be connected with the judgment that has been passed. Regarding about an inquiry, first so cause was issued. I participated in the first so cause. Secondly, my lord, thereafter, there was no inquiry report which was furnished to us. I filed a writ petition in 2025. Thereafter, we came to know that affidavit was filed by them and the inquiry report was annexed in the affidavit in the present case. Then I found that there is no inquiry, the inquiry officer has concluded there cannot be, this officer cannot be charged. Now, what normally the law is that Then either you send to DA. DA has to take a decision on that. Now DA doesn't take a decision. A second so cause was issued to me, saying that no, a fresh inquiry, inquiry, the inquiry officer appointed, present day officer was appointed. Now the issue is whether it is permissible. This is the case, my lord. Now,
Meaning
please see,
you say that the de novo inquiry.
it's a de novo inquiry. Please see, and there is no outcome of the first inquiry. My lord, there is a provision, I'll show it, my lord. If you see, my lord, the case first, my lord, and it will be easier to connect. See, my lord, at page 48, 3291 of 2025, read petition. Please see 48 now, the facts, my lord. This is, my lord, he was appointed on 2/6/2023 as acting Deputy General Manager Marketing. What you got it? At page 48. Now, there was an interview for the post of DGM, which your lordship will find at page 49. So, the DPC interview, it was informed, my lord, to appear in the interview for promotion to the next higher post. Lordship got it, my lord, at page 49. Now, there was a
No, what exactly is your challenge here?
my challenge is the second so-called which has been issued. If you see the affidavit, please see the first affidavit, then I'll show what is its challenge. Please see the affidavit final at page 157.
157. Yes.
This is 1/11/2024. Please take this in one hand, my lord. Please take this in one hand and please see my writ petition first. Please take this and see my writ petition at page 64. This is the first so cause which was issued. Lordship got it, my lord. At page 64.
64.
Yes. 64. Whereas Sri Subodh Kumar Singh, while discharging duties as acting Deputy General Manager in Marketing Department, has received audio clips, 2 numbers from one of the marketing dealers, that is from Dhananjay Tiwari, Bihar, wherein it was clearly evident from the conversation of audio clips that you have solicited money, advise him to hand over the requisite amount to so and so, Ajit Singh, Manager Marketing. In this regard, you are aware, as per Employees Conduct Discipline and Appeal Rules, the act and action carried out by you falls under misconduct as per clause number so and so, taking or giving bribe of any. So this is reproduced, my. Now, thereafter, I have given a reply at page 65. I denied my reply from page 65 to 67. Now, please turn to page 68. These are article of charges at page 68. Right, my now at page article charges page 68 to 72, my lord. Now 73 is a statement in defense which the petitioner has made it to the Honorable CMD. DA. Got it?
Yes.
Now, thereafter at page 71, this is a memorandum. 74, notice to a charge-sheeted employee of holding inquiry. Also got it, right? Now, at page 76, the inquiry officer, my first sitting, MP Sinha, GM, Tech, and C. Pranjal Borgohai is the presenting officer. This sitting, 4 sitting they have consecutively, one has been done from page 76 to 80. 76 to 80. Now, 76 to 80, man. 81, I have written a letter to the disciplinary DA. Please see this, man. Please refer charge sheet number so and so dated 18/5. It was intimate to management and the alleged charge level against me. The inquiry officer was appointed to conduct the disciplinary proceeding. During last inquiry hearing on 3/10/2024, I were instructed by inquiry officer to submit the closing argument. Accordingly, I submitted on 16/10/2024 the said closing argument statement before inquiry officer. Then it was informed by inquiry officer that inquiry proceeding is completed. I also came to know inquiry report has been also submitted by him to Honorable DA. Since more than 8 months have been passed toward initiation of the inquiry committee, but I have not received the inquiry report so far. So I therefore request inquiry may be pleased to provide for me for compliance under so and so. So I submitted. Now please see. Now I am taking to your lordship at 157 of the affidavit.
Yes.
Now please see. 1/1/2021-11. This is when the affidavit was filed by them. The undersigned was appointed as an inquiry officer by memorandum number so and so dated 18/5/2024 to inquiry into a charges level against Sri Subodh Singh, Chief Manager. Inquiry was conducted in the office chamber of the inquiry. So these were number 2, kindly see. No documentary proof for any monetary transaction amount paid is available in the file. Also, Lordship got it, file.
Yes, yes.
There is no witness for the case under consideration. 3, the charge officer claimed audio clip is doctored and he never had such type of conversation with the complainant. He further stated that he has lost FIR with so and so against the dealer for criminal conspiracy against him as he was receiving threatening calls. 4, verification of authenticity of the audio clip is beyond the domain of the inquiry officer. 5, in the recently concluded quarterly review meeting, Honorable CBO stated the Vigilance Department inquiry is conducted based on the documentary evidence available in the file. G, for the above mentioned nature of allegation, charges for which no documentary evidence or witness are available in the file, any conclusion to department proceeding is not possible. Proceeding so and so and closing argument is original. So they could not find any, my lord.
Where is the charge sheet?
Is at page 60. Our sheet is at page 68. 68, man. 64 is a memorandum. See the 64, my lord. See 64. 64. Got it, 64. Whereas Sri Subodh Kumar Singh, while discharging duties acting DGN in marketing department, has received audio clips, 2 numbers from one of the marketing dealer, that is from Dhananjay Tiwari, Bihar, wherein it was clearly evident from the conversation of audio clips that you have solicited money and advised him to hand over the requisite amount to so and so officer, that is Ajit Singh, manager marketing. So in this regard, you are aware, as per employee's conduct, so and so, misconduct as per 7.275 is reproduced. So this is one. And next, my lord, at page 68 is the article of charges. At page 68.
68 is also some memorandum.
Yes, memorandum. Now, annexures is at page 70. Page 70. Lordship got it? 70.
Yes.
This is a statement of article, frame under so and so. Conversion of audio clips, that so and so. Article of charge, page 70, 71, and 72. Now what they have done it. Please see where my lord at page 1, Lordship has seen that affidavit which has been filed, nothing was found. They could not find anything. Now please see at page at page 60, 81. 81 I have given an email to them. Please see 82.
So after the inquiry report, what happened?
No, they
After 157,
nothing. They could not give anything on top. What they have done, please see 94.
90.
Please 94.
Yes.
In the affidavit, they did not give the inquiry report to us. Only when the affidavit was filed, the inquiry report was submitted. In fact, by an email, we have written to them. Please give us inquiry report. Please see 94. 4/2/2025. Got you got it?
Yes.
An internal department inquiry was made on alleged audio chat matter of SKC, chief manager, for receiving bribe money to a tune of 566 lakhs in return of giving dealership appointment. MP Sinha, GM, who was appointed as an inquiry officer, has submitted report on 1/11/2024, where logic find at page 157. Subsequently, now see my lord, the management has received a common representation from 3 workers' union, wide reference dated so and so, against the charge officer Mr. S.K. Singh, where 2 unions have claimed that during the month of May 2024, after mobile chat came into public domain, representatives of the 2 said union had a discussion in the chamber of GM marketing, where Mr. S.K. Singh, the then, has confessed to have collected the cash from Mrs. Amarnath Enterprise against outstanding dues of so and so. When he was asked why the money was collected in cash instead of bank check, he kept mum without any further answer. Upon representatives are ready to appear as a witness on the matter, considering the new facts comes into picture, the inquiry has to be conducted afresh based on above circumstantial evidence. In this regard, the DA has decided that Samit Mahapatra, GM, is to be appointed as a new inquiry officer and Mr. Vikram Talukdar will be the presenting officer. It is desired inquiry report may be submitted to undersigned 45 days. So this is what we were agreed. Even then, my lord, we were called by the inquiry officer. We appeared and they asked to give us voice sample. Now we came to the court. He said these are not permissible. I appeared. That is true.
So this is prior to the issuance of the memo.
Which one?
This 194.
90. The second memo. This is a second memo.
Second memo.
Yes. Second memo, my lord. Second, inquiry officer was appointed newly. The presenting officer was appointed newly. Now, when a DA, now he doesn't say anything about the inquiry report submitted by earlier inquiry officer. Report. Please see, MP Sinha, they had page 94, who was appointed as an inquiry officer, has submitted report on 1/11/2020. Now, what is that report? Your Lordship has seen the report at page 157.
Yes.
And this report is furnishing to the trade union, which it is not being furnished to us. And they, however, these two trade unions now come into the picture. What was the basis of this inquiry? How it started with the first inquiry? I appeared, inquiry officer appointed, presenting officer was appointed. Inquiry report now has been furnished to the court. Now only for the purpose to fill up all this gap and lacuna, you came with a second minor so-called, appointing new inquiry officer based on 2 of the unions. Now please see now of the judgment of this court. That's why I showed the judgment. Normally I place normal facts, but here, if you see at page para 33, once again I'm troubling this court. Now before that, My lord, before I trouble with the judgment at page 33, there is a rule that I want to show. Very narrow campus the matter of life. This is the issue. Please see the rules. The employees conducted disciplinary appeal rules, my 17 2021. Please see page 38. 38.
Yes.
Now please see 34. Action on the inquiry report. Also got it? The disciplinary authority, if it is not itself the inquiry authority, may, for reasons to be recorded, by it writing, remit the case to the inquiry authority for fresh or further inquiry and report, and the inquiry authority shall thereupon proceed to hold further inquiry according to the provision of Rule 33 as far as may be. So if he is not the inquiry authority, mind, if there is an inquiry office or authority officer who has been appointed, now the inquiry report which has been furnished to him, there has been reason to be recorded, and he may say that no, what he'll do, I will remit the case back again. I am not satisfied. This is the reason why I am not satisfied. Nothing has been spelled out here in this case. And the same inquiry officer, my lord, kindly see, by writing, remit the case to the inquiry authority for fresh or further inquiry and report. So, my lord, where is the question of a de novo inquiry in this case, my lord? Yes, de novo inquiry, further inquiry, and fresh or further inquiry. What way the application of mine by the DA? What is the reasons you have recorded? Then nothing has been recorded. He said that no, we received from two trade unions to representation from the trade union. We have got witness. Now, if you see what is the judgment of this court at para 33. This is what your lordship, this court has expressed. Thereafter, after proper analysis at page para 33, lordship got it? Of the judgment, of the lordship judgment. Therefore, upon proper analysis of the judgment discussed above, it is seen that in all the judgment on the facts of each and every case, it is seen inquiry conducted earlier either concluded in favor of the delinquent officer, thereby the inquiry officer concluding that charges are not proved, or that there was no sufficient evidence to sustain the charges leveled against the delinquent officer. In all these matters, the DA in each of these cases disagreed with the conclusion arrived at by the inquiry officer in favor of the delinquent officer. Here, my lord, where is the question that you have said that no, this inquiry, I am not satisfied with the inquiry which we shall conduct. Either this way or that way, it will be decided. In other words, the conclusion arrived at by the inquiry officer did not appeal to the DA, and a consequence thereof, de novo or fresh or second inquiry was instituted. Under such circumstances, coordinate bench of this court as well as the apex court considered and concluded second inquiry conducted was not permissible. Now, my lord, what happened in the second inquiry? Yes, he went. You asked for voice sample. I said there is nothing given. Why?
Now, page 95 is the, sorry, 94.
94.
This is the inquiry. This is the order.
Yes. Right. For
The
second.
charges are the same.
Charges, no, the charges is in regard to one Dhananjay Tiwari. Your lordship will just recollect. This is the same. 5 crores, 5 lakhs. Charge is same.
We are asking you, respect of the first charge sheet.
Yes.
Memo of charges.
Yes.
There were certain charges against you.
Yes.
Statement of allegation.
Yes.
Now for this de novo also.
Same. That's the charge. Yes. That's the charge.
The matter is proceeding now.
Now there's a matter. Second, we came up before the court. And what is a prayer? That's your lordship asking me what is your prayer. I came to the court, my lord, under the interim order which was passed by this court. What has happened in 2023 when this post, my lord, the post of the GM, Deputy General Manager, for marketing. My lord, that was DPC. We sat for DPC. An interview was held. And accordingly, they did not. My lord, the result were not out. Then we came up before this court. If you see the interim order passed by this court, see the order of this court on 13/6/2025. 13/6/2025. What you got it? Order of this court. At that time, when 2023, there was no inquiry against me. 13/6/2025. 13/6. What you got it?
Yes.
The petitioner, who is presently posted as chief manager under the Brahmaputra Valley Fertilizer Corporation, has approached this court of filing the present writ petition multiple grievances. Primary grievance of petitioner is that having spent all his professional life in the service of so and so marketing division, having acquired requisite skills and experience in marketing department, respondent have illegally and arbitrarily shifted into a training department, which in a way amounts to downgrading of his professional stature. His Barua father submits that although our client has appeared in the DPC interview held on 13/12/2023 for the post of EGM marketing, yet his result have been withheld till today for no valid reason, although the results of similarly situated other candidates have already been declared. According to so and so, result of a client has allegedly been withheld on the ground of pendency of the complaint inquiry against the petitioner. Although no such inquiry initiated in accordance with law is pending to the best of knowledge of which petitioner. So and so has also emphatically argued clients the victim of malafide action on the part of departmental authorities. Therefore, present his case is a fit case for interference by this court. By inviting attention of this court to advertisement dated so and so, has further argued that with a view to deprive the petitioner of a legitimate claim for appointment at DCM, respondent have advertised the said post for filling up the same by way of direct recruitment. Therefore, an interim order of protection is called for in this case. After going to material record, after submission, this court is of opinion. Prima facie case is made out by the petitioner. So it's now, my lord, will see, having regard to the facts and circumstances of the case entirely, it is ever provided. Respondent may proceed with the recruitment process initiated by the advertisement dated, but shall not issue any final order of appointment for the post of DCM of the say advertisement notice without notice.
Are you challenging the appointment or you're challenging the departmental proceeding?
No, departmental proceeding, there are multiple, my lord, the prayer which has been made in this case.
Permissible.
My lord, please see.
You're challenging the,
No, my lord,
you're seeking
now
a
please see.
direction
Now
regarding
today-
publication of results.
Now, please see.
Washing
today-
of the action is so and so in
Yes.
transferring.
Yes.
Then you are asking for setting aside of the initial inquiry report and direction. Then for initiation of fresh departmental proceedings. They're all separate causes of action.
No, what I'm saying,
Direction for release of salary.
no, what I'm saying, my lord, today, as on date, your lordship will not see my promotion order now, because apparently on the face of it, they cannot, because there is an inquiry which is. Cannot, your lordship, this
So
cannot.
first, tell us what are you
No, we are
challenging
challenging,
here?
we are challenging the second inquiry, which was second, so cause. If that goes, my lord, subject to your lordship has to hear it. If that goes, my lord, then automatically, so far as the first inquiry, nothing remains with the first inquiry.
So you're now present, revenge your prayer before the court is only with regard to the second inquiry.
Yes,
That's all.
yes. If it goes, my lord, then, my lord, because of the first inquiry, your lordship has seen the report. Please see the report at 157. What is the report?
So we have seen that.
Yes, nothing was found. Where is the question of a de novo?
What does the rule say regarding
Yes.
inquiry?
Yes. 34.
Yes.
DA, if it is not itself the inquiry authority may, for reasons to be recorded, by it in writing, remit the case to the inquiry authority for fresh or further inquiry and report, and the inquiry authority shall thereupon proceed to further inquiry according to provision of Rule 33 as far as may be.
So the disagreement note is it here somewhere?
Where is that, my lord, disagreement?
Not here. In the affidavit somewhere? No.
I have not found any disagreement. Subject to the argument that will advance on my learned friend. Any disagreement or note, my lord, then I'll come to know what is the disagreement. This is my case, my lord.
Yes.
Let me begin with page 94. Now, 94 is not on the same set of charges. But I must be fair to your lordship, my lord, 94 is not proper according to me. It is not a de novo inquiry. It was a fresh inquiry, but it could not have been done in this manner. A proper memorandum of charges ought to have been issued. So it will be difficult on my part to defend this order. Because as my learned friend has said, it is on the same charges, it is not on the same set of charges. Lordship will kindly come to 64, my lord, for a moment.
Sixty-four.
64.
Yes.
64 says that, my lord, 2 audio clips were received where the petitioner is demanding money from one Dhananjay Tiwari of Bihar. I am not reading it in details. Now, lordship will kindly come to 94. 94 is saying that some union has filed a complaint alleging that he has confessed of taking money from some Amarnath enterprises. So these are 2 separate incidents.
Where is the inquiry report?
That 157. I'll come to that. Now, what was initiated with 64? That inquiry report is at 157. Now, this 4.2 is a separate complaint, madam. 4.2 is not a de novo inquiry or a fresh inquiry into the earlier allegations. But I have to submit, my lord, that this could not have been done in this manner. A memorandum of charges up to have been issued.
But then he has not, you not submitted your reply. 94?
No, 94 is difficult to submit a reply, I must, because there is no memorandum of charges. Only that there is a complaint filed.
Set aside.
94 may go, my lord. Now we are coming to 157. What does 157 say? My respectful submission is, my lord, 157 does not exonerate the petitioner for the disciplinary authority to disagree with 157, my lord. 111 says, point number 4, verification of authenticity of the audio clips is beyond the ambit and domain of the inquiry officer. So now what we have done, my lord, we have asked him, please give your voice sample. Because the second stage of 34, to start a fresh inquiry, my lord, on the same materials, no fruitful purpose will be served, my lord. Now he is declining to go before the forensic, my lord, to record his voice sample. He is not giving the voice sample.
You're not powerless to compel him.
I am powerless, my lord. I am not the police. How can I, my lord? Lordship will kindly see page 95. 96, my lord. At first, he himself says that he is willing to.
No, see, 94 you admit.
Yes,
that
ought
this
to
is
have
not
been.
a fresh inquiry.
Cannot. It is not a fresh
It is not a
inquiry.
de novo inquiry.
It is not a de novo inquiry.
It is a fresh inquiry.
It is a fresh inquiry. Ought
But
to have been.
not in terms of the
Not in terms.
rules,
My lord.
right? So therefore, whether he has agreed, he has disagreed will be
No,
irrelevant now.
If lordship limits this writ petition to the page 94 order and leaves everything open, my lord, then I have got nothing more to submit.
That is what he says, that you are
Because
challenging
now
the
he has
de novo,
to-
isn't it?
So what I am saying, what my learned friend is confusing, now what is that? There is an enquiry report which is submitted at page 154 or 157.
Yes.
157 you submitted. Now, what is saying what normally it does, the enquiry report has to furnish before DA. DA has to take a call on it. Where is that, my lord? Now, what they done on the basis of the second so-called, where the new enquiry officer, they are asking for audio clips. Yes, this is what, please see this. 94, 95, please see 95. Yes, there's a new one. This is not the earlier enquiry officer. This is a new enquiry officer you have appointed.
This is the senior manager vigilance is asking, my lord,
No,
page
no.
97.
How can you go ahead with that? You are asking in connection with this enquiry. Please see. You are asking for on basis of this enquiry. My lord, when you did not find anything, where is the question?
No, now in view of the submission that this is not as per the rules.
Let it be, yes, let it go. Then we'll do.
Let him give his first sample, my lord.
No, why that? That cannot.
Voice sample with regard to what?
Yes.
Those audio clips, my lord.
But those audio clips subject to your disciplinary proceeding disagreeing that.
No, there is no question of disagreement, my lord, because lordship will kindly read 157. Is there any finding that he has exonerated him, my lord?
No, but there is no finding that he is.
Exactly, my lord. The inquiry officer says.
In fact, the last line of para 6 is,
Yes.
it's not possible to arrive at any
Exactly, my
conclusion.
lord. So, will that matter end, my lord?
No. This issue is not even vexed before this court.
It is, my lord.
No.
It is.
No,
Because he
where
is saying that this
where
is a
is the-
subsequent inquiry, my lord.
Where is the direction? Where is the prayer made that whether you can go for any inquiry, further inquiry, no inquiry? Is there a direction sought for? They are not seeking for a direction.
He is not seeking for a direction, my lord. He is
If the
seeking for
rules permit, go ahead. If the rules don't permit, don't
rules
go ahead.
permit, my lord. That is why we are asking him to give the voice sample. He is not giving it. That
He
is
is
why
not-
this
he is
inquiry
not-
is stuck.
If he's not giving it, can there be a direction in his writ petition that you go and give? When there is no prayer,
Lordship will have to give some leeway. That
you take whatever procedure.
Lordship will give us that liberty. Lordship will give us that
Of
liberty.
course, that liberty is to be there. Yes, Mr. Das.
This enquiry, second, so that should go, my lord.
All right.
Second suppose will go, my lord.
No, that's it.
But
Your whole case is relying. Your whole case, you are relying on that. That's why you are asking for that the voice sample. And very interesting, my lord. If you
Lordship
see
will kindly see 160, my lord, for a moment.
158 is 158. How the trade union having those inquiry report?
We are not going into anything.
No, I'm saying
Now,
your trade union, you want to develop a new case now by bringing these two trade unions.
whatever they want to do
Yes.
is up to them.
And
But they have
that
considered that
is
this
why
is not
we are-
as per the form.
Yeah, before this court only for that reason. Don't try to develop this case on the basis of your report. You could not find anything.
We can't give you a
Yes.
blanket order that henceforth no case shall be
No, I don't
instituted
say.
against you.
Can I say? I will not say that.
So we are therefore we are asking you in the view of the long prayers that you have, many prayers that you have, what are the prayers that you are pressing now? So as on date, one inquiry has arrived at a conclusion that it's not possible to arrive at the charges being proved. This is one. Whether the departmental authority, disciplinary authority accepts, rejects, or is one aspect.
Yes.
Now, in the face of the submissions made by the respondent, that 94, not a fresh inquiry, not a de novo inquiry, or not a question of reopening, it's a fresh inquiry. So, if it's a fresh inquiry, it has to be as per the rules.
Yes.
I heard Mr. D. Das, senior counsel assisted by MSP Purva, Mr. N. Deka, assisted by Mr. N. Appearing for respondent number
226.
6.
226.
226. For Mr. A.K. Dotto appearing for the respondent number 1. The petitioner is an employee of the respondent number 2 corporation. And is serving in the post of deputy manager,
No, chief manager, no.
chief manager,
Another department, business development department.
The rank of chief manager.
serving in the rank of chief manager. During his service, petitioner was served with a memo, memorandum of charges by the respondent authority initiating a departmental proceedings. Where is that memo?
64 and 68. 64.
By memo dated 24/4/2024. So, in response to the memo charges, the petitioner filed his representation, written statements, and the inquiry proceeded. The inquiry officer, on conclusion, has returned the finding that 157 on the grounds and reasons mentioned therein, that any conclusion through the departmental proceedings on the allegations and charges is not possible. So, subsequent thereto, the respondents issued another show cause notice dated 4/2/2025, where on the basis of which the inquiry officer and presenting officers were appointed and the proceedings were initiated. So,
Order, man, 4/2/2025. At page 94,
yes,
it is an order.
at this stage, the petitioner has approached this court, praying for interference with the order dated 4/2/2025 and the proceedings thereunder. So, the case projected on behalf of the petitioner, parallel, is that this order of 4/2/2025 is a de novo inquiry or a subsequent inquiry initiated by the respondent authority on the same charges. It is submitted that such action on the part of the respondents of initiating a de novo inquiry is not permissible under the law, under the as also enunciated by this court as well as by the apex court. So it is submitted that in terms of the roots, it is only in the event that the department disciplinary authority disagrees with the findings of the inquiry officer, and that too under limited circumstances, that any de novo inquiry can be initiated. So, submitted that by the order dated 4/2/2025, there is no disagreement of the disciplinary authority which is reflected, which would have resulted in a de novo inquiry. So, it is at this stage the petitioner had come before the court. What was the interim order?
Interim order was with regard to the advertisement, not with regard to the disciplinary process.
The learned counsel to the petitioner also submits that because of the disciplinary proceedings, the petitioner was not considered eligible for responding to an advertisement for appointment to the post of
post of deputy
Deputy
general,
deputy general manager, marketing, at the relevant point in time. At this stage, the petitioner had approached this court, and this court by order dated 13/6/2025, while issuing notice, had directed permitted the respondents to proceed with the recruitment process initiated by the advertisement notice number HR/11/2025/02, but shall not issue any final order. One, the post of DGM marketing within bracket E7, serial number 4 of the advertisement notice without leaving the interim order came to be extended from time to time. It is still subsisting. Interim order,
They, in the meantime, they appointed somebody else.
whether the interim order is still
Yeah,
subsisting.
there is, it's up.
Per contra, the respondents have contested the case of the writ petition by filing their affidavits. Submitted that the conclusions of the inquiry officer by order dated
1/11/24.
1/11/2024 is not an exoneration. It does not exonerate the writ petitioner from the charges. So it has given the reason as to why the final conclusions could not be arrived at by the inquiry officer. Stop. The disciplinary authority is yet to take up a call. Findings of the report of the inquiry. It's further submitted that the notice or the order dated 4/2/2025, number so and so, is not a de novo inquiry. So submitted that on a perusal of the stated 4/2/2025 and the memo charge earlier issued dated 10/5/2024 will reveal that the charges against the writ petitioner are not one and the same. Stop. By the order dated 4/2/2025, view of the allegations, in view of the charges, view of the representation made by the workers of the workers union, the proceedings have been initiated. Stop. Mr. Decca, however, barely submits that Mr. Decca submits that as on date, no final decision has been taken by the authority in respect of the earlier proceedings. Therefore, there is no bar to initiate proceedings on the basis of fresh allegations or charges leveled against the writ petitioner. Stop. So far as the advertisement is concerned, what happened?
I don't have any instruction from that.
Advertisement concern, my lord, they have already appointed somebody else. They have appointed.
Then, having heard the what did you, Mr. Das had pressed into service the judgment rendered by score WPC 6452 of 2020. Having heard the learned counsel for the parties and upon perusal of meetings available, see that according to the petitioner, the order dated 4/2/2025 is an order in directing de novo inquiry respect of the writ petitioner, notwithstanding the conclusions arrived at by the inquiry officer and the submissions in his report of inquiry dated 1/11/2024. So, par contra, the counsel for the respondent submits that the order dated 4/2/2025 does not pertain to the same set of allegations. Plain reading the order would read that it is pursuant to certain allegations leveled against the writ petitioner on the basis of representation received from the workers. It is necessary to refer to the relevant Brahmaputra Valley Fertilizer Corporation Limited as its employees within bracket conduct discipline appeal rules of 6. Describe in part 5 discipline. The procedure, the penalties, both minor and major, are listed, and the procedure for imposition of major penalty as also procedure for imposition of minor penalty are described in detail. So, so far as the memo of charges dated 24/4, sir, petitioners, in response to the memorandum of charges, which is followed by the articles of charges dated 10/5/2024, submitted with written statements. So the explanations given not being satisfied with by the disciplinary authority, the inquiry officer and presenting officers were appointed and the inquiry proceeded. And by order dated 1/11/2024, the inquiry officer submitted the report. So, as per the rules, 34 prescribes the action on the inquiry report. 34 is extracted below 34. An appraisal of the rules reveal that in case of any disagreement by the disciplinary authority on the findings of the inquiring authority on any article of charge, it will record its reasons for disagreement and record its own finding, and if the record is sufficient for the purpose. Recording the reasons for disagreement, it will forward a copy of the report of the inquiry and along with a copy of the tentative reasons for disagreement to the delinquent employee. Stop. The report of inquiry by the inquiry officer dated 1/11/2024 has concluded that the conclusions to the departmental proceedings with respect of the allegations leveled against the writ petitioner are not possible, and the inquiry report of the inquiry is extracted below 157. So, in terms of the provisions of the rules as discussed above, the departmental disciplinary authority is required to take actions either by accepting the inquiry report and issuing closure orders of the inquiry proceedings, or record its reasons and grounds for disagreement by issuing a disagreement note and furnish the same the delinquent employee, calling for response from the delinquent employee before proceeding in the manner prescribed on the rules. So, Whereas Mr. Deka, learned counsel for the respondent, submits that the departmental disciplinary inquiry is yet to come to a conclusion with regard to the findings, and therefore, at this stage, the matter is still pending with the departmental authority, and therefore, no decision is taken by the department to proceed for de novo inquiry by issuance of the order dated 4/2/2025 as sought to be projected by the petition. So, categorically submits that the order dated 4/2/2025 is not disciplinary, not a de novo inquiry. Stop. He further submits that the order dated 4/2/2025, the fresh departmental inquiry is being proceeded with against the writ petitioner on the grounds and reasons and the allegations mentioned therein. Since the counsel for the respondent categorically submits that order dated so and so, by order dated so and so, the department is not initiating any de novo proceedings. Therefore, the consideration, the arguments, respect of whether, respect of the parameters as to how and when a de novo inquiry can be initiated, need not be addressed by this court. So, the respondents categorically submit that the order dated 4/2/2025 is a fresh inquiry on the allegations which are reflected in the same order. So, upon perusal of the pleadings before the court, it seems that this order dated 4/2/2025 initiating an internal departmental inquiry is a standalone order. It is not accompanied by the statement of allegations, the list of witnesses, the list of documents, as is mandated under the rules. So, the rules are very categorical as to how charge memo is to be issued. The procedure for imposition of major penalty is prescribed in detail under Rule 33 of the conduct rules. (33)(1) provides that no order for imposition of any major penalty specified under clauses F to J of Rule 30 shall be made except after an inquiry is held in accordance with this. 33(3) prescribes, lays down that the departmental authority shall deliver or cause to deliver to the employee a copy of the articles of charges, the statement of imputations of misconduct, misbehavior, and a list of documents and witnesses by which each article or charges is proposed to be sustained. And on receipt of such articles of charge, the employee shall be required to submit his or her written statement of defense. And if the employee so desires, the employee may be heard in person. So the statement is to be filed within a period of 15 days. So a plain reading of the rules, as also a plain reading of the order dated 4/2/2025, reflects that the order dated 4/2/2025, although reflects that an internal departmental inquiry is being made with respect of the writ petitioner, the procedure prescribed in the Rule 33 has not been followed. So, such circumstances where the statutory rules provide proceeding initiated against the departmental against a delinquent employee, the same are required to be followed. Are strictly required to be followed. So the departmental inquiry under the rules, if it culminates in imposition of a major penalty, will visit the delinquent employee with civil consequences. Therefore, procedure prescribed of the rules must be rigorously followed. If any proceeding is initiated under the rules without following the procedure prescribed and laid down under rules so and so, prima facie amount the violation of the principles of natural justice, as also the protection given under any employee under Article 311(2) the Constitution of India. Authority, more particularly a public enterprise, is required to carry out, if it is required to carry out a particular act in terms of the rules set, then it must carry out said act strictly in terms of the rules or not alone, or not at all. Refer. Under such circumstances, this court is constrained to hold that the proceedings initiated by the order dated 4/2/2025, treating it to be an internal departmental inquiry against the petitioner, is totally in conflict with the procedure laid down under the rules, read 33 of the so and so rules. So, consequently, the proceedings violate not only the statute but the principles of natural justice. Therefore, it's arbitrary per se. So, the proceedings sought to be initiated against the petitioner by the order dated 4/2025 were therefore interfered with and set aside. So, the department is given the liberty to take a decision to proceed against, if it takes a decision to proceed against the petitioner, then the procedure prescribed under the rules must be followed and sufficient opportunity be granted to the petitioner defend his charges. That view of the matter, the writ petition stands allowed, the extent indicated. That's it.
Lordship has said statutory rules. These are not statutory, my lord.
Rules prescribed.
Rules prescribed.
Yes,
Otherwise, on
Public.
contempt,
the counsel for the petitioner, what they give, the counsel for the petitioner for the present seeks indulgence of the court to, in respect of the prayer for interference with the de novo, the fresh inquiry. The other prayers made in the writ petitioner are not pressed.
at the present moment. The liberty should be given, because the salary not paid, that's also one issue. We,
Since no finding is arrived at by the court, needless to say, in respect of the other prayers, petitioner will have liberty to urge the same if the needs to arise.
yes.
So, interim order stands vacated.
Yes,
There's a contempt.
yes. Because there is an order passed by this court saying that you
In
cannot
view
go
of the
ahead.
order passed today, in WPC so and so, contempt case number so and so stands closed. This is the issued, stand withdrawn. Yes, boss. This is a case of where there is a nominee by the Oriental Insurance. And their claim is that they are the legal heirs. They seek a direction to the Oriental Insurance to release the amount.
To the nominee.
No, to the legal heirs.
Legal heirs, they will have to establish whether they are legal heirs.
That's right. So as far as the deceased and the insurance company is concerned, there is a privity of contract
Yes,
that in the event of any death, it will be released to the nominee.
exactly.
Now they have placed before the court a judgment of the apex court, which you may like to go through it, where perhaps the petitioner is trying to impress on the court that there is a decision by the court that mere name in mere inclusion of the name in the nominee is not going to entitle them to that fund, the amount, the
Exactly.
benefit.
The legal position is correct.
But it is the legal heirs will have the claim. But
That's
that
true.
is
Nominee is a custodian.
a nominee is a custodian, but this claim will have to be made in a proper forum.
Yeah, exactly. It will go to the civil court only.
That's right. But they have not filed it as on date.
And
So we propose to close this petition by observing that in view of this judgment, there is no quarrel with the legal proposition. As and when if there is an order passed, whatever release you have to make insofar as the nominee is concerned,
Right.
you release it subject to such orders that may be passed by a competent court under
very well.
the succession law,
Exactly.
determining their claims vis-a-vis the amount.
Yes.
My lord, my case is some difference, my lord, because my contact is not directly with the insurance company.
No.
Because I am the employee. I was the employee of the police department. The group insurance is there. I am my premium was given in the group insurance,
Right.
and that amount deposited by the department by a MU in the State Bank, and State Bank done the insurance along with the Oriental Insurance Company. So the government also involved in my case, and the insurance company and State Bank also involved. In that case, I can't say the only private respondency is not involved in this case to file the title suit or any suit to get the relief.
The judgment you are relying on, if this is the judgment you are relying
Yes.
on, if I have read it correctly, then it says that the amount can be claimed by the heirs of the assured in accordance
Only
with the
for
law of
observ-
succession.
Yes, yes, madam. Only for observation of the Supreme Court is very clear in this regard. That's why I was relying on this judgment. But my case is some difference. My case is some difference. So I approached the court and I put my
So what orders do you want from the court?
direction as per provision of the law, that is a succession law.
Let us-
Succession will be involved, and
let us see.
accordingly, that
Let-
is a Muslim law will be conduct in this case. So their share they will get. I am not saying that they will not get this year. As per the Muslim law, father and mother also get this year, proportionate share, and wife and son also get this year.
You show us the provision.
Yes, my lord. There is a law in the so in Muslim law, my lord. The class of the hair, there are the three class of hair, namely sharer and residuary and distance.
See, you claim to be the legal heirs
Yes, ma'am.
vis-a-vis the nominee.
Yes, there is a nominee.
Right.
Nominee in the bank, my lord. In
That's
the
right.
bank, when I was not married, then the father and mother was the nominee in the bank.
Right.
On all of a sudden, my husband was died in accident. So nominee was not converted. That nominee was before my marriage. On the bank only. On service book also, I am also nominee in the service book.
You have received the pension.
Yes, everything, others benefit, I will receive. Now, till now, I am not
Now,
getting. all the
where is
benefits.
where is the insurance agreement?
So that is the MU is there, my lord, done by the department, my lord, along with the insurance company.
You serve a copy to Mr. Dotto, he is for the insurance company. Serve
So,
a
my
copy
lord,
of the
they
petition.
are receiving the notice, but they are not appearing. If required, then I will serve them.
Yes, you can
Copy.
give him a copy,
Yes,
if possible today.
yes.
He will go, then we take up again on
That's better.
Monday or Tuesday.
Tuesday will be.
Tuesday. Matter be listed on Tuesday. The counsel for the petitioner will serve the copy of the writ petition with enclosures. And the private respondent will, as also the government will serve copies of their affidavit filed in the writ petition. The counsel appearing for the insurance company, Mr. S. Dotto, senior advocate. Mr. Dotto has appeared in the court on the request of the court. Matter be listed on Tuesday.
My interim pair. There is
Interim-
interim.
There is an interim prayer.
Yes.
Already
Interim order is there.
order
Interim
is
order.
there. Interim orders, if any, will continue till the next date of listing.
Must.
Huh? No, what part? Which part?
Lord, in regard to item 26,
Yes.
Lord, may I make a request to come up on Tuesday?
26.
The transfer matter.
Let us take it on 24th. 24th?
Take it up immediately after the meeting.
Lord, it's
Immediately after.
almost
They are-
Whatever
they are-
date is convenient.
They are
6
pressing
months,
for
my
a,
lord.
they are pressing for a hearing.
Yes, any day as convenient.
Before
We have no
vacation.
difficulty, subject to Mr. Dotto
My lord,
agreeing.
as your lordship said, 24th, it's okay. So we should not bargain, my lord, after vacation. It's an urgent
day.
matter, he knows that it's an urgency there.
We have been
So let it be on 24th, since
Yes.
they're pressing for a hearing. It will be on 24th.